welcome to the December 14th regular meeting of the Calaveras County Planning Commission, and we will get started with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, to the republic which stands one nation, indivisible, with liberty and justice for all.
Are there any staff announcements or agenda changes today?
Yes, Madam Chair, there is a change to the agenda. The revised agenda would remove informational item B1 on the greenhouse gas plan. We're taking that off the agenda for this meeting. And because I may have to leave around 11:30 a.m. For, some very important reasons, I wanted to announce and provide you with a list of projects that we have approved since our last Planning Commission meeting. I'm going to hand them out to the Commission after I announce them. The first one is a short-term vacation rental. It's a renewal for a property on Lakeshore Court in Copper. That was approved on December 11. And the other two items were items that went to the Board of Supervisors yesterday. And they were for a zone change in general plan amendment for the Faith Lutheran Church in Murphys. And I think this is the Hammerson's project. Went to the Board of Supervisors yesterday and was approved.
Thank you. Okay. Then Annette, is there anybody online?
Thank you.
There is not.
There's not. Okay. So this is our general public comment period. An opportunity for any member of the public to speak to the commission on an item not on the agenda today, but within the subject matter interest of the Planning Commission. And seeing nobody, we will open and close that item. And we have the consent agenda, which includes minutes for which there are not 3 members who were in attendance at those meetings. So I believe we will have to continue a number of those unless our new commissioner has listened to any of them yet.
In fact, I didn't know I was supposed to listen. I was wondering.
I thought you had volunteered, but I didn't.
It was only on one particular one that we discussed.
Right.
Can I agree to do so now?
Oh,
We
yes.
need to do so in the future, yes.
Okay.
I'd have a question for legal counsel, and that is can a person who was not yet a member of the commission listen to a tape and approve minutes?
I think so. I think as
I'm
long,
glad.
yeah.
Because otherwise we're dead in the
Right.
water.
I mean, I think it's just a matter of having everybody agree or that is in fact, they reflect what happened.
Yeah.
So.
I think, on some of these, we ought to wait because maybe Commissioner Parker will be agreeable to watching some tapes without nailing Commissioner Lozano with all these. Anyhow, we have some that we can approve.
Yeah, I believe that we can take care of October 25th, 26th, and November 8th. But the earlier ones, we will need to go ahead and continue to our next meeting.
I also moved in 25th, 26th, and November 8th.
Okay.
I second that.
Okay. I think we have a motion and a second on the ones that we can handle today. So all in favor?
Aye.
Aye. Any opposed? None. So 3002? No, 302 absence. What order we're doing these in?
Yeah.
But it's really 3011.
Yeah, that's right.
Thank you. Okay.
So shall we negotiate on the others at this point? See which,
Negotiate on.
well,
them?
which ones Commissioner Lozano is willing to listen to?
I don't think we can speak for Commissioner Parker since he's
No.
not here,
No, I
so.
know we can't. So we'll wait till we're at least up to 4 to discuss those.
So they're continued to not necessarily our next meeting, but so I think, is that your question? Do we
Yeah.
not set a
So-
date certain for that?
We can, yeah, continue the minutes that we're not acting on today, we can continue to the first regular meeting in January.
Correct. We may not be able to handle them at that point
I
either.
understand.
Yeah. Is that,
I mean,
that's what we have to do, we
Yeah.
think. Yeah. Thank you. Okay. So I think we've taken care of it, and at that meeting, we'll see where we're at, right?
Yeah.
Okay. There is nothing else on the consent agenda. There are no items on our regular agenda today. So we will move to item B2, which is now B1. The continued discussion on the comprehensive update to the county zoning ordinance.
and I just wanted to say that I invited Mr. Packinger, Public Works Director, to come here to, I know we're going back a little bit, but the parking regulations were definitely in his wheelhouse. There was a lot of language in there, and this was a good time for him to maybe speak to us about any concerns he has about the draft.
Great. So should we take care of that first so he can actually get back to his day
I
job?
think so.
Okay.
Let's see, where's parking?
1707.
Yeah.
In the countywide reg.
Right.
Okay. Page 28. Beginning on page 28.
28, thank you.
Good morning,
Good morning.
Robert Packinger, Public Works. I provided comments to Gina regarding the pertinent code sections on parking. For the most part, my comments were to add references to back to areas where we have kind of an overlap in regards to parking. The kind of overlap that we have is mostly construction standards, I guess you can say, because there's stormwater issues that need to be addressed. If parking lots get paved, the stormwater that comes off of the parking lot, the pavement carries oil with it. So we have standards in our design manual for taking care of stormwater. We have standards for vehicle fueling locations and different things like that. We want them to get encroachment permits if it's on a county maintained road and that's the type of stuff that I provided to Gina. So at this point, unless you have questions, it's in process. We've been in communication, and when she finishes what she's doing, I'll review the drafts and make sure that things are included.
Okay, so as I understand it, then you and Gina are working out proposed additions or revisions
Yeah.
to what we've already looked
For
at.
the most part, the language is fine. I offered some clarification. And then just to add a few code references to our codes.
Uh-huh.
So can I ask a question about that? I know that for purpose, because the zoning code update is also going to affect some yet unknown sections of county code that lie elsewhere, because we don't know necessarily every place in our code that might be touched by this change. We were gonna be adding language to say that to the extent the zoning code update conflicts with any other provisions that the new zoning code controls. In your case, do you feel it's important that we have your existing ordinance control? Or do you feel like there are not any real conflicts? Just was wondering what your advice would be on that.
I don't remember that there was a conflict. I think our codes were more specific
Okay.
in regards to some of the parking issues. There's a lot of parking, in the parking subject, there's many things in there that don't pertain to us.
Okay. So should, if
So
we just said,
we don't handle whether or not the parking is paved. That's entirely up to planning. The number of parking spaces, the orientation, is that type of stuff in the design is entirely in planning. The things that we care about is what happens with stormwater and encroachments and.
so just refer to that for additional standard, to your chapter for, and design manual.
Right, I don't remember that there was a conflict, but if there is, when Gina goes through her draft and updates the pertinent section, I will look at it again and make sure that there's no conflict.
Thank you.
Yeah,
Okay,
it
you're welcome.
seems like we could just say there are additional requirements, specific requirements contained in Calaveras County Public Works Design Manual.
Right,
And maybe even give them a little hint that they primarily pertaining to construction standards, encroachment locations, that kind of thing.
Yeah.
Stormwater design.
I think that was similar to the language that we put in there, right?
Yes.
Okay, we're thinking the same.
So, Gina, are we going to see these before we get the final draft?
We're gonna hide them from you.
That's perfectly fine.
We wish they could be hidden from us.
Just kidding. The plan is, once we get through admin, Martha and I have already been working on bringing forward all of your suggested edits in a red line version. What we plan to do is compile all of these sections together and bring back to you a complete code that includes things that we haven't seen so far of, you know, other figures and tables and,
Yeah.
things like definitions and other parts that we've not reviewed in
And that
this
would
form yet.
include these.
Comment
Yeah.
from any
Exactly.
side parties as well.
Right. So we've been incorporating those as we feel, you know, necessary as per our discussion and things that we've noted as we're going through the documents again. So we'll bring back, like I said, a redlined version of everyone's edits, and it'll be a document that is a full, complete document.
A full.
Yeah, so it'll be like looking at it brand new.
A big, new, beautiful
That's
document
right.
in multicolors.
Yes.
Okay, it sounds like you're on track then.
Thank
All
Right,
you.
thank you.
Thank you.
Thank you,
for-
Robert.
Thank you for looking at this now and not after we've taken a final action.
That would be very horrible. No, it's better to do it now.
Oh, yes.
All right, thank you.
Thank
Thanks.
you.
Thank you.
Okay. Then we will pick up where we left off, which is, I think, page 16 of the admin section, 1702-100. My notes say December
Yep.
14th, start here. Oh, and there's Martha. So Gina and Martha, is there anything you want us to take a look at before we start right in here? Or is this all good? Please don't.
I
go
think you
back.
can
Is
just
that what
start.
you-
Please don't go back.
Okay,
Yeah, I think we're ready.
all righty. So do you want to start hearing from us, or is there anything you guys want to say?
Just hear from you.
Okay.
Take it away.
Okay. Um, In the very first paragraph, but toward the end of the first paragraph, I just have a question about the language I don't quite understand. Previous uses no longer occupying the same site or location. And occupying to me speaks of persons. I'm not clear on what the meaning is of that. This is under paragraph A, scope at the very end.
Maybe occurring on the same site or location. I think occupying works, but
I'd be more comfortable with occurring, but that,
Which page are you on, sir?
We're on page 16, first paragraph, A, under scope.
Scope. Okay.
We're looking at the last sentence. Unless otherwise specified. Go on.
I think occurring could be fine.
Yeah.
We'll double check, but I think that should be fine.
I think either one works as far as I'm concerned.
So change occupying to occurring?
Yeah.
occurring on, I guess.
or at.
At. I can go for at. Then I have a more major question as far as subsection C. It talks about how if things are done not the way it was presented in the application, the approval shall be deemed null and void. And seems to me, and I'm willing to be dissuaded, is that really instead of actions voiding approval, that paragraph maybe should be saying revocation of approval. Because if it's just deemed null and void, then some step has to be taken in order to establish that in the real world. I'll read you what I think would be good, and if you like it, I will go slower. The approval may be revoked if any express or implied condition of approval is violated. Then that takes in, we've already talked in subsection B about how conditions are implied, or the, I'm trying to find it, okay, the site plan, floor plans, et cetera, shall be deemed conditions of approval, so that's why I'm saying express or implied. I guess we could say expressed or deemed.
So my concern with it had to do with, don't we have to have a revocation hearing?
Yes,
Yeah.
yes.
Yeah.
So
It seems
Oh,
like.
yeah.
I
mean,
I
we
think
could
the
say-
idea of deeming something null and void is an administrative decision that we could make within our own department through our planning director. But you're right, in order for us to revoke a permit, then there's a process involved in that.
I don't think it can be null and void until it's actually revoked.
Exactly.
Okay.
Okay.
So it seems like it needs
So then,
approval shall be.
I mean, I'm happy to leave it to you and Martha as far as what the wording might be, but just indicating that it's,
But
That-
section C is referring specifically to the construction of a building or a structure, though. It's not referring to a discretionary application.
Yes, it is.
Unless-
Or the use established.
yeah.
So if the construction of a building or structure or the use established is contrary to the description or illustration in the application to either violate any provisions of of this title or require additional permits, then the approval shall. To me, this means that there are uses that are allowed by right that are not discretional.
But that's,
So-
That's
not what
this
this is talking about. It's talking about a use
Mhm.
that is contrary to the description.
Right.
To
So it-
violate any provision of
Right.
this title. So I think your situation would be covered by that
Right.
section.
So this is action that we've taken to approve, for instance, a use permit,
Discretionary.
a discretionary action where we have specifically looked at an application with a site plan and said, this
Yes,
is approved.
right.
If the applicant is then therefore constructing something or, you know, outside of what we've approved, say they wanted a 2,000 square foot metal building and then what ends up is a 4,000 square foot.
You know
So-
what?
so-
Can I just say that you really have a point though, I
Yeah.
think, because you know, we have these zoning clearances now, we're not used to those, and so
Okay.
if that is added to our code, I guess the question is this intended to also, if we're doing zoning clearances, that it would be for like a building permit, but the thing is that the building permit has to be revoked by the building official, not by planning. So I'm just not sure what the intention
Yeah, I'm not-
is here.
I'm not sure.
But they're talking about something that has been,
Are we voiding the application submitted for the permit to construct the building? Or are we voiding the action taking to approve the construction of the?
that's the way it's worded, is that the approval shall be deemed null and void.
Any approvals received relating.
I wonder if we can just back up a second as I'm reading this. I wonder if this even needs to be stated because we already have statements on violations and enforcement that if you do anything contrary to your conditions or violate any provision of the code, that you do go through this enforcement and potentially revocation process. So
That makes a whole lot of sense to me, Martha.
So just
Especially
delete-
because it's repeated in each particular
Yeah.
approval type.
So just delete
Right.
C then?
Yeah, or I was gonna say, or it could say the approval may be subject to
Yeah,
revocation.
pursuant
Which
to
would
sections of
be,
the.
yeah, exactly. If we wanted to keep some overarching language in there.
So I think I hear the issue with something being deemed null and void and the need for the revocation process. I think what Gina and I will do will kind of comb through all of this because I know if that statement is said in places and just kind of clean that up.
So I'm not sure how you wanted to enforce, I think what's new, Martha, is the zoning, is this sort of, we're building in a formal review process instead of just a behind the scenes review process for some permitted, non-discretionary.
Right,
what's the
just
word?
verification of
Right.
that it's compliant.
Ministerial approval. So we're verifying ministerial approvals. And I guess the question is, do we want to just put as a caveat, do we mean like periodic review? Are we meaning discretionary approvals or are we meaning ministerial approvals?
So now you're moving
We're
on
on
to
to the next
subsection G.
one. You're in the next
I'm just, but
section.
Martha's talking about doing a global change, and I guess I'm just suggesting that we remember that we now have added one section that is for review of ministerial permits. And what happens if we say the use is allowed, but only to this extent, but if it goes beyond capacity 300, then it's a discretionary permit, and then they go ahead and do 300 for 350, do we enforce that? Because we're reviewing it for purposes of a building permit usually, or some other ministerial permit.
But it always says
But-
in a way that is,
But a building permit
violates
is,
provisions of this title. So
but we haven't previously approved a building permit, so.
And you, right, and so I just want to make sure that we don't make it
You're
sound
providing
like.
clearance that
Right,
allows them to
we're
get
providing
building
clearance that the use is allowed, it's not, otherwise
And isn't,
a plan that we've previously reviewed in a public hearing process and said, this is approved.
yeah, and so isn't that clearance is just a statement that as of now, what you are saying, what you are proposing fits within the zoning?
Right.
And then,
It's
then that,
appealable to the planning commission, but
Yeah.
that decision,
Yes.
but I don't
But-
think we would be enforcing the violation
I-
later on if we want to revoke our clearance. That's sort of what I'm
no,
asking.
so I don't think,
Yeah.
I don't think that makes sense because
Right.
we're clearing what was presented at that point. And-
Okay, I'm just saying you might want
Yeah.
to make
No, it's a
sure that
good-
the language in here doesn't accidentally capture or can't be interpreted to capture.
I think that's why Martha
Yeah.
I am pointing at an image on a screen, so who knows what I'm pointing at when other people look. But yeah, exactly. It looks weird, sorry. I think that's why she's saying to clean up the language and say maybe, or so that it softens it and we can make a decision, or the planning director can make a decision of whether that makes sense in any particular case. Is that correct, Martha?
Yeah,
Okay.
That's great.
Now we can talk about periodic review, which is the section
Yes.
that I had all that sort of,
Good,
are we gonna do periodic review? Because
yeah.
we don't.
Well, I think normal planning practice is that we should be doing periodic review, but it depends. If we're gonna do periodic review, then we need to, for discretionary projects, we need to identify that period within the conditions of approval. You know what I mean? It's got to be stated in the conditions that, this approval is subject to periodic review every 365 days, every 2 years, every 5 years, so that it's not something we're springing upon the applicant at the very last minute.
Do we have to do, I don't know that that has to
Historically.
be. I think we can always enforce our code with or
Right.
without a condition.
And it
And
says
this is-
they may be subject, and if a condition specifies that it will happen. So I think this wording is actually okay. I think this is more of a global question of what we really plan to do, given our limited resources.
Well, wouldn't this really, would arise when somebody
Yes,
raised a flag saying?
just the same old thing.
Yeah.
Yes, when someone complains.
And if, as long as we keep it as may be subject to periodic review, I think it works.
Right. So everyone's okay with kind of leaving this as is and moving on?
Yep.
Sure. So I'm going to assume that our staff and legal counsel are gonna check all the dates and numbers, and that's not something we need to concern ourselves with. You guys are gonna make sure we're always in compliance with the.
We double check each other. like
I mean, I think,
Yes.
I'll look at, I think that the legal compliance with state law pieces is gonna be looked at mostly by Minty or Harnish. But yeah, I mean, I'll do my best to see, to catch, where there might be something in our county code. I had a question. We were talking here about no building permit or business license shall be issued.
Where are we?
Where are you?
Oh,
What section are you in?
I thought you're down at 1702-1110.
We are, but where in
Oh,
there are
A1.
you?
B1?
A1.
A1, okay.
Oh, at the end, no building permit or business, yes.
I mean, we have a business license ordinance that's, that the tax collector is in charge of right now. And it's not even clear, there's some discussions about business licenses and whether they need to be separated from land use approvals entirely. There's been some issues around that, that's still being discussed. So do we want to say whether, and then we're not in charge of when a building permit issues either. That would be the building department under a separate code section, so I just don't know about that.
Well, the issue though is a a business license is not issued until all the departments actually sign in. So if we in the planning department refuse to sign the business license, it's not issued. And I think it's become a problem whereby we issue business licenses too quickly before, getting issues resolved. And I think this is one of the checkpoints for us to make sure that we don't issue a business license for a business to operate without them going through the necessary
But
process.
we don't issue those, so maybe just, maybe,
What I'm understanding here is that what we're talking about here is the date of the action at the end of A1. We're talking about the action of the planning director.
so no, planning shall not sign off on any, shall not give clearance for any building permit or business license, since planning doesn't issue them?
Wait a minute.
But that's not what
Yeah.
it says, though. It says no building permit or business license
Right.
shall be issued. So puts the,
I'm suggesting that it be
That would
changed
change the language.
yeah.
to say,
Well,
planning shall not provide clearance for any building planning shall not provide Title 17 clearance for any building permit or business license until the 16th day.
That would be a better,
Okay.
Well, I thought that was the action that was referred to. The clearance is not the action.
No, it says shall
the
be
action is
issued.
not the clearance.
Yeah, planning department is not the issuer.
No, I understand that. And that, I was with you on that.
Yeah.
I guess, when we're talking about a final decision on an application for any approval, I was thinking that's approval by the planning.
Right.
By planning.
Yeah, that approval is right.
Yeah, and then, it doesn't mean that it's a final
says
approval for the,
Approval subject to appeal.
Yeah.
So that is a good question in terms of, back to Gabriel's point or Julie's point, or both, about a clearance. So a clearance is typically subject to appeal, because any action by the planning director is subject to
Yeah.
appeal. But you wouldn't necessarily, it seems like that would be a very unusual situation where someone is appealing ministerial clearance.
I don't think it's that. We've had some of those. I don't think, especially when it's showing up in the zoning code, I actually think people will
Right,
become
'cause
more
it's a
aware.
new thing.
but
It's
isn't the
official.
issue that we're dealing with here is about the last sentence, that we don't want to give the impression that the planning director's action after the appeals period is passed is the final decision for the granting of the building permit or business license. It's just that there's got to be at least 16 days after the planning approval before the other agency can issue the license.
That's true, Commissioner, but I think the issue here is the language which stays issued until after the 16th. And the point county council is making is that
Yes.
issue suggests that the planning department
Yeah,
issues
you're right. I mean, if we
licenses,
can-
and we don't.
Martha, can you solve this problem for us?
Well, I think Julie,
Well,
Provided
yeah, I think Julie's language.
Okay, what?
hopefully, in my opinion, I think that sentence actually could just be deleted. It's really in there to be like helpful in that, like, hey, you can't get your building permit. Like if you require a use permit for a restaurant, I'm not going to issue your business license for a the county is not going to issue your business license for that restaurant until you have that use permit.
So, yeah, I mean, if the business license process gets divorced from land use in the next 3 months, we wouldn't.
So what I'm,
Yeah.
right. So what I'm saying is, like, the intention is that is just supposed to be like a helpful statement, because that should be true. Somebody should not get a business license for something they don't have the ability to operate.
Right.
That being said, we could take that out and it's not going to change anything. if it's
That's
causing
true.
more confusion than help, we can just simply take that statement
Yeah.
out.
I like that idea.
Yeah, I'm for that.
Yeah, because a lot of times people are getting a business license that's a continuing an existing use or a business in their home. And we're not.
Well, and it
make-
gets a little awkward if you're talking about those truly, project-related actions.
Right.
And I think,
Instead of, what I think you guys are talking about is more of a, this is a ministerial project, but maybe we make a decision that someone might object to, that is appealable. I mean, anything we say, any interpretation we make is appealable.
and I think, it's helpful to the applicant if, when the decision is made, state, this is just the decision of the planning department, doesn't mean
Right.
final approval of the
Yeah,
license.
I think Julie's language took
I like
care
that
of
as
that, but I still see a lot of things. I think that will be more clear when we look at when you need to get that zoning clearance. Because clearly, if you're getting a permit to replace your roofing, you don't need a zoning clearance or you're gonna get checked off, but you shouldn't have to wait 15 days to get your permit when you would normally get it
No.
over the counter.
I think this is intended to be purely, subject to those discretionary actions.
So do you want to add discretionary approval?
Yeah, that's what I
We
was.
could.
So just put in the word discretionary, so it's all discretionary approval?
Right.
So a final decision on an application for any discretionary,
Mhm.
let's put discretionary.
And then use Julie's.
Bill, signed off.
Well, what, the planning director shall not provide zoning clearance.
Yeah,
Except if it's a discretionary approval, it's not a zoning clearance.
right.
Right, then
I think I like Martha's suggestion is just take it out.
Yeah.
Just take it out?
I think it's
Yeah.
good.
Okay.
Just remove the last sentence completely.
And it seems like the building license or business license process has its own challenges that
Mhm.
need to be looked at separately.
It does.
Okay, that would be the
Okay.
easiest thing to do.
Very good.
So if we're moving on to subsection C, I'd go to C2 on page 17. And I think for permits or approvals not requiring a building permit, then I would cut to the second part, the second requirement. So it's for permits or approvals not requiring a building permit, the permitted use has commenced on the site and a valid, cutting back, a valid county business license, if required, has been issued. The way, the order we have it now, if you don't need a business license, you still have to have the permitted use commence on the site. So I think you just reverse the order of those two conditions.
Okay,
And put the words if required after business license.
got it.
Also, I think it should be more parallel in the language. Instead of has commenced, like up above, it says construction lawfully commenced. It could be and the permitted use has lawfully commenced on the site.
Uh-huh.
Just
So
so that they're more
the same.
similar both in
Yeah,
tense, and just overall language.
and drawing attention back to one, I think probably in construction has been lawfully commenced on one.
Yeah. Oh, boy.
I can withdraw
I
that.
know, no, that's fine. I start down that path and then.
Well, I figure this is our chance to make things read well,
Yes.
and,
Are we ready to look at D, or is there anything else in C that anybody has any thoughts on?
I'd go to D.
Mm-hmm.
D2, I'm gonna read it. The planning director may approve a two-year extension of any permit or approval granted on this title upon receipt of a written application with a required fee within, and then insert the word either the time period specified by the review authority or 2 years of the date of approval, of the approval. So just insert the word either
Yeah,
for the time period.
that's a nice.
Just keep in mind that the Subdivision Map Act is not in this title. So those map extensions are not going to be covered here.
Yeah, so
Right, that's why it's
Hopefully
under
that's
other.
covered somewhere.
Later,
Other.
I had questions about that there's a lot of times where we say something, but that could be modified by state action that automatically extends things. So I don't know how we want to cover that. Like after 2008, there were a lot of automatic extensions.
But other extensions don't apply to maps.
It doesn't apply to maps because maps are not in this
Right.
title.
Right.
I just want to make sure nobody here thinks that
Oh.
discretionary map extensions are going to be covered.
No.
Exactly,
Right.
but when we sound like that's the only extension available, it's not always going to
Right,
be the
right.
case. That's all I was saying.
I mean, Title 16 could use a rewrite too.
I know it was a weird period of time,
Yeah.
so. Okay,
Okay, subdivision E. I think the word lapse is very good, and I would put it in, I'd simplify the first sentence a bit by using it. When a permit has been validated, it shall lapse if, and then cross out remain valid and in force unless. So it's lapse if the use or structure, or the structure authorized by the permit, blah, 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 blah.
so don't we already have this requirement in our zoning ordinance? That if a use lapses, and I thought it was
Yes.
for a year,
Yes.
so I just
Yeah.
was speaking to
That's not
another.
conforming uses. That's specific to
Ex-
that.
Yes, right. Something that required
Well,
an
it
approval
also,
of
it
some
also,
kind.
yeah, it also applies to uses that have been permitted by action
The
against,
conditional
with a use
the
permit.
Administrative use.
Right.
Right, because another design professional told me that they were completely unaware of that. They thought that if a space had ever been used in some way, that they could resurrect it if it had been empty for years. But they brought up a good, and I said, no, you better go read that. But they brought up a situation in which there had been a fire. So the space had been just unused. No repairs had been made, but other portions of the building remained in use. So do we have what kind of provisions do we have? Can that
wiggle
be
room?
extended for if there's some extenuating circumstance, what kind of extensions? It says the revocation permit shall be can be reactivated with a new permit, but can they get an extension under those circumstances?
Madam Chair, let me ask an introduction question. So was the use approved ever implemented. So let's say.
Yes.
Yeah, okay, so we,
Although it's more, this one, that example falls apart at this point. It just made me think of this because I'm not sure it was a non-conforming use and I'm not sure it was ever a legal
okay, yeah,
non-conforming
that-
use,
that
which I
goes-
also brought up to them
right,
that
that's,
they needed much more research
Yeah.
before an answer could even get to them.
Right.
But it just made me think of this and that we need an extension for a disaster.
Right. So I think what Michelle is saying is we've approved a conditional use permit for a restaurant. And there's a kitchen fire and, for whatever reason, they don't get permits to fix up the kitchen again and the restaurant goes idle for 2 years.
Right.
Somebody else buys it and wants to, start reopen the restaurant without getting a use permit. She's saying, is there another provision that, under certain circumstances that we can basically just say, yes, this is a unique circumstance. You don't need to go get a conditional use permit again. We are very willing to just
What about fire in
reinstitute the use.
1953?
Well, no, I think it still needs some limitations on it. So I was just saying, can there be an extension in those cases? A lot of times insurance hangs up somebody from
Yeah.
getting their repairs done within a year.
if it's a use that is approved through a conditional use permit, that's UP runs with the land, right?
Unless the use is.
Right, unless the
Yeah.
use is discontinued. The way the code reads now and the way this is written is unless the use is discontinued for more than 12 months.
Okay.
But just to clarify, what can happen after that 12 months is that the county may revoke it through that process. It doesn't say that the approval is null and void or the approval goes away. There needs to be that kind of due process. You can't just take away the permit. So if it has been discontinued for 12 months, the county may go through that revocation process.
Because right now we say has been revoked. So
Right.
no use of
Does
land or
say
structure.
maybe.
Yeah, the permit for which has lapsed in compliance with this section has been revoked in compliance with section da.
And then in my
Okay.
understanding is that that a jurisdiction just can't revoke without allowing a due process.
Yeah. Oh, I'm looking at the wrong sentence. So up in the middle,
Yeah, in the middle, it's
Yeah.
may be revoked.
may be
So-
revoked.
So
that-
discretion's built in. Discretion to be
Yes.
built in.
Right.
It's
That's-
built in, okay.
Yeah.
So in general, because the county may not know, I mean, you're not even gonna be thinking about, you're not gonna go all over searching the county for a place where somebody has stopped doing something.
Right.
So it's not going to be revoked
Until
unless it
somebody comes
to your
in.
attention.
Right.
And they
yes.
don't.
And that's
the county
usually
doesn't
what
wanna do it.
happens.
And,
It's
well,
usually what happens is it comes to us in the form of a building permit or an inquiry from a new buyer. Somebody's asking questions or submitting plans, and that's usually when we catch it. So, I think in the case of a fire, there should be adequate records to indicate when the fire happened, and, the planning director could make that judgment
Or
call.
if there's a disaster of some
Sure.
kind, we know about it.
Yeah,
And this also assumes that this is not a non-conforming use. This is
Right.
for conforming use.
Of course, it would only matter
Right,
if it was
right.
non-conforming.
Right.
Or they had a discretionary permit.
yeah,
Yeah, okay,
okay. Are we happy with it?
yes.
Okay. Point 130.
1-3?
120?
3,
130.
revocation.
Revocation of a permit?
Page
Oh, you have some others?
I was just
18.
on 1702-120.
Yeah.
I would just, and I don't know whether it needs, I almost think we might want to say it, any revision that would change a mitigation measure imposed under CEQA should be, I think we should almost
Is
say,
major.
is a major revision.
Yeah, I agree.
Because there's a process we would have to go through it would require a CEQA document of some sort to change the mitigation measure or some sort of findings.
So, yes, if they had any required mitigations or.
But, I mean, that isn't covered by this language or a
No.
revision that would intensify a potential impact of the project.
It's not there are circumstances where we'd have to do an analysis of whether we can change a mitigation measure, and depending on the analysis of how that would change a potentially significant impact, it may or may not require a more substantial CEQA document. So I would just add a sentence under major revision saying any request for revision or any revision that would have the effect of modifying a mitigation measure imposed under CEQA shall be deemed a major revision.
Okay.
Actually, when I read this, it says a request for revisions to conditions of approval of a discretionary permit, a revision that would affect a condition of approval, or a revision that would intensify a potential impact of the project shall be treated as a new application. It doesn't say shall be treated as a major revision. So is a major revision a new application? Because to me, there needs to be a difference between what would constitute a new application and what constitutes a major revision, and then what a minor revision is.
I think that the titles of this, I think the language makes it clear that if a major revision is being requested, they need to
It's
do a
a new
formal
application.
application.
Right.
Okay, so then why have a major revision category then?
Because to let people know the distinction.
Right.
Yeah, I see what Gabriel's saying, actually, but I think this is okay. I think adding either another piece of information that says any revision that has the potential to result in changes to mitigation measures, imposed under the original approval should be deemed a major revision, however Julie said it.
I would actually say CEQA. just
Right,
because-
and
Actually,
I put secret.
I mean, don't we
Yeah.
want to really say a major revision requires a new application and then state what major
Is that-
revisions
is that
are?
what-
Okay.
Exactly.
The question, is that the intent? Though, because if the intent is we can have a minor revision, we can have a major revision, and then we can have a new application. So if a major revision is a new application, why don't we just call it a new application? That all major revisions.
Because it has to, I think that the fact that we're saying it's a new application is because it's not something that can just be reviewed and approved at an
take
administrative level. It takes a public hearing.
Like a CUP
Right,
modification.
right, which is,
AUP
I
modification.
was gonna say, well, maybe we
Which is
just
a
need to say
process.
a major revision requires an application for modifications to the original permit
Okay.
or amendments to the permit or whatever.
instead of
you
making
want.
it sound like a whole new
Instead
project.
of a whole new
Right,
project,
Right,
exactly.
right.
That sounds
right.
good.
That's
Martha looks
Well,
concerned.
all that then, but if you then say a request for a major revision requires a modification to that permit, what is a modification to that permit then? Is that processed the same way as a new permit? How, I just don't want to, so when you name a process, then we need to have a process.
Okay.
So what is that process then?
Yeah, because, we don't currently have a process for a modification, but we do have a fee on our fee schedule.
Yeah.
Well, I've seen modifications
Yeah.
to CUP come through here.
Well, yeah, but I'm saying we don't have a separate, our code doesn't, I don't think we call out a separate,
Maybe we just have
Process.
amendments to discretionary permits at we need to define it somewhere and.
Well, why don't we just say as a new or modified application? I mean, then it covers all these.
Well, I think saying that they need a new one, and so it's an entirely new project, seems,
I think we're losing we want to still
Yes.
maintain the connection between the existing project
exactly,
and,
we're not
to
opening
me-
everything up, we're
me,
looking
yeah,
at,
to
what
me-
does this change really do?
Well, and could we just say that, an application for revision which will be processed in the same manner as the original application?
Yeah. An application to amend the original shall be processed by the same body and in the same manner as, I think that's what you're,
Yeah,
yes.
but as the planning director was reading the first sentence, it raised a question for me. A request for revisions to conditions of approval of a discretionary permit. Oh, I see.
Yeah.
A revision that would affect a condition of approval. I was trying to draw the distinction between those two.
Well, I mean, if the commission remembers, we had a project where we wanted to remove a condition of approval. I came before the planning commission. Removal of the condition of approval was based on that condition no longer exists, but that doesn't make the application a new application. It's still the same application. We're just taking away a condition of approval, which might be considered a major revision as opposed to a minor revision. So that should be three things: minor revision, major revision, and a new application. And making a major revision a new application process, to me, is not,
Great.
it's not what the intent should be.
Yeah.
But we wouldn't add new application here. We would just, we have that existing elsewhere in our code.
But it's written here.
Yeah, it
Yeah.
says.
See that? So, shall be treated as a
Be
new
treated as a
application.
new application. I think we just want to say shall be treated as an amendment to,
But don't we want to say, okay, where do you go for that process? Well, you go to the process.
that's
same
what Martha's
It's
saying.
a
is-
Same process as.
It's a modification.
yeah, I think, and shall be decided by the same review authority
Yeah.
as the initial.
Okay, yeah.
Permit.
No, that's.
So we want to maintain the connection between the changes and the old project while not necessarily changing the process and not calling it new. I think we can probably play with that a little bit, don't you,
I
Martha?
think that's what they.
Yeah.
Without reinventing the
Here.
wheel, yeah,
Yeah,
Yeah.
Okay,
okay.
that's
We don't,
good.
I think the intent is not to add another process, but to simply somehow roll this one into the existing process.
Right,
Right.
and acknowledging that it's an amendment
Right.
to an existing permit, not.
So are you just going to delete shall be treated as a new application?
No, we're gonna say
They're gonna
something
play
else.
with it.
yeah, we're gonna play with it.
Okay.
Yeah,
That's what I need to hear.
especially because we have a different fee schedule for those amendments. We don't want to imply that they're gonna pay for a whole new
Yeah,
project. And make sure we mention CEQA. Okay, now we're back to 130 revocation.
okay. In the first sentence, any permit granted under this title may be revoked or revised or for cause if any of the, and I would say replace conditions or terms of the permit are violated, or if any law ordinance is violated, replace that with saying if any of the events set forth in subsection C has occurred. We've got all these required findings under subsection C, which would seem to cover.
None of them say that there's, oh, I see, it does say a local law or regulation.
Or you could keep it saying if any of the conditions or terms of the permit are violated, if any law or ordinance is violated, or any of the conditions listed in subsection C.
Yeah, I think the reason I said events instead of conditions is that
That's,
some of it are not
yeah,
conditions.
no,
Okay,
yeah, that-
okay.
This is just a technical question. Under A, under what circumstances would the Board of Supervisors initiate a revocation proceeding?
I'm not sure, but I would think if somebody comes to a supervisor with complaints.
Right.
Then
Yeah,
that's not.
because
they're
they
not
can
really-
initiate anything they want.
Yeah,
And it isn't that they would continue with the hearing as the first, as
Right.
the,
they
They
come
can-
to
Review
planning,
body.
but they might be.
So
the
they will
initiator.
call for a
you,
revocation process.
Right.
right.
I think it's more just to recognize that ultimately they're the ultimate
Sure.
Yeah,
authority.
yeah, that's true.
Not that they'd likely do it.
Pen is in the chair.
And Chair almost went down.
Then,
Actually, having said that, though, under our current code, only the Board of Supervisors can revoke a business license.
uh,
So,
Yeah.
then I just have a form suggestion for C4, if nobody has anything before that. Since,
I just
Hang on,
had underlined common procedures, so we're gonna have something that defines, these are the common procedures.
where are you there?
B, public notice hearings and action, but it's mentioned in other places. And I think these procedures we're talking about are the common procedures,
Well,
but
what's it, well, what chapter is it in our draft here?
we don't have it. I mean,
Oh,
we
I
don't,
thought
we
we
might have something that says common procedures. I'm just saying, is there something, because it's capitalized like it's a section.
Well, I think that's a chapter.
So
chapter
it is a chapter, and it's
Oh,
the
it's
chapter
here.
that,
Chapter
It's here.
determined, yeah.
But it's the things we're talking about right now,
Yeah,
right? Yes.
yep. Okay,
Because the planning commission also has its own separate rules of procedure, I'm wondering if we should make sure to authorize the planning commission somewhere the planning commission may adopt additional rules of procedure separately. I don't know, just to make sure
Well, there
there's
was somewhere else I
ordinance
thought,
authorization for it.
yeah,
I thought that there was something somewhere in here that it seemed like that belonged. This wasn't where I was thinking, but yeah, maybe in this common procedure
Yeah.
section.
Yeah,
Um,
I mean, it might also be in
talks about
22 or
our- the way we
3.
conduct a hearing,
Yeah.
right?
Yeah, I think there are other code sections that deal with this.
Yeah, we have those adopted. It's just like a policy though.
but I don't know that that's reflected in here, which is, I think,
Well, that's, I agree.
Yeah.
And
Somewhere we should
somewhere
have
I
ordinance
noted
authority to
that.
do it.
Yes, exactly.
And I don't know, I'll have to look to see whether we have it.
we did address that in the conduct of public hearings of like, and we made it general, any applicable procedures adopted by the county.
okay, great.
By the county suggest the board of supervisors.
Right, so maybe we just need to refer
Or planning
to
commission.
By
the planning commissions. Or here, because the Board of Supervisors also has separate and
Yeah.
slightly different hearing
Yeah,
procedures than we have. So maybe if we could by the Board of Supervisors or Planning Commission.
Okay.
So are we down to C4?
Yes.
Okay, it's just, in C4, it starts, there is or has been a violation of or failure, et cetera, et cetera. And then the next one is a violation of, and then the current language says, or the use has been conducted in violation. We just need to change that, just to keep the parallel form, take out the word "the" and just say "or a," and take out "use has been conducted in," and you end up with "or a violation of the provisions of this title." It's just
Yeah.
to keep the form the same.
Okay. Are we done with C? Because I have a question with D.
I have a thing on 5 where it's just a wording thing. The use has been conducted in a manner detrimental to the public safety, health, and welfare, or to be a nuisance.
Yeah.
Or it needs to be, or has been found, deemed to be a nuisance.
Yeah.
They need something in there.
There's something,
Something missing there.
yeah.
Oh, it has been deemed a nuisance.
I don't know that there's any nuisance out there that wouldn't be detrimental to
Yeah.
public health. I don't know if we need to say nuisance, then it gets into that situation where the building official determines nuisance enforcement. Right? I mean, it would capture nuisance determination without having to say it.
Or maybe, or has been determined to be a nuisance and leave it in there so people, because safety, health, and welfare sounds so technical, and I think things like noise violations, they do violate the welfare, but they don't seem like they fit cleanly into safety
Yeah.
and health. I don't think it hurts anything
Yeah, just say it's
to
been
put
deemed
people
a
on notice that
Right.
things that seem like they're just a nuisance can rise to the level of revocation.
Any violation of a county ordinance is a nuisance per se.
Legally.
So do we need to say by who? I mean, nuisance, who declares whether there's a nuisance? Can that be anybody in the county?
I would just say it's determined to be a nuisance and not say who's determining it, because it's probably gonna depend on what it is.
I mean, nuisance is a legal term of art, is what I'm trying to
Yeah.
say. And and that's why I'm just wondering if it's causing, I mean, public welfare, the public health, safety, or welfare, we could just say or, and then any nuisance will fit. Without having to use a legal term of
Yeah.
art.
Okay.
I'd be okay with that.
Do we want to, since this is under these events that the planning commission may revoke, but do we want to say something that the use has been conducted in a manner, do we want any sort of unreasonably detrimental or something of that sort? Because no.
I think that's just me, I don't think
Yeah.
it's necessary.
I don't think it's
I think that we're
necessary.
gonna
It's
have
fluff.
fights over reasonable.
Okay.
Right.
I think in later provisions, I'm going to be raising the question.
Well, and in other sections under required findings, we use or and after every single item to make it clear whether you need to have multiple findings or any one
yeah.
of them, and I thought maybe that belonged in here.
To have or welfare.
Well, yeah, the approval was obtained by means of travel or misrepresentation of a material fact, or the use, building, or
I see.
structure. That's the format that
Well-
we've used in other places.
I mean, the or, I could certainly argue that the or at the end of 4 would do it, but I agree that it's better to probably put the or. after
Yeah, it's just we've done it every other
Yeah.
place there's a list, or in most other places, we have a list like this. And it says that we're being clear, any one of these
Right.
would.
Yeah. So, under D, this is a legal question for Julie. It says, the director shall issue a notice of action within 7 days. If the director does not issue a notice of action within 7 days, what does that do to the action that was taken by the planning commission?
I don't think it disappears. I think this is a direction that you have to move quickly. To let them know that they're not allowed to do it.
Is it
So
Do
why,
we
why
say
7
somewhere
days?
whether it's calendar days or working days?
We
Just
should.
globally?
And I think also, like, for this, part of, I don't know if we're discussed notice of action elsewhere, but sometimes we'll have,
Yes.
we need, sometimes we'll have, an absentee landlord who won't know that the leaseholder operating is the one whose use has been revoked. And so the notice of action really should go to the landowner as well as to whoever the
We
applicant.
talked
to
about
include-
this,
Do you have to include a timeframe? Can you just eliminate
We don't
that?
have to.
Shall issue a notice of action?
Yeah, just,
I don't think it's required legally. I think that's a policy decision.
Yeah, just to say act quickly.
whenever you want.
I think we need to have a time frame, and we need, so we have talked about this notice of action term and that it includes any sort of final, whether it's an appeal or an approval, just something documenting that it happened. We talked about it, I don't know if it was last time or the time before.
It's gone.
It's all running together.
Could you just say a timely notice of action?
I mean, for CEQA,
Well-
there are specific
But this is,
number of
But, yeah,
days. I'm
You
just
have
saying,
to be specific, you have to give a specific time frame.
Yeah.
So typically, we take the action at the meeting and it's pretty immediately that information is transmitted to whoever. Sometimes somebody's not even here for it.
Yeah. Yeah, I just wondered if the planning director did not do that, does that invalidate the decision of the planning commission? In what way does it affect it? Because in comparison to CEQA, if we don't do certain things by certain dates, there are consequences.
we could say failure to issue, if you want a time frame, we could say failure to issue the notice of action within this time period does not invalidate the
Yeah.
planning commission
Okay,
decision.
that's all I wanted.
I mean,
That way
that
there's
makes
no
sense.
argument.
That makes
Yeah.
sense.
That's actually a good solution.
Yeah.
Yeah,
So we say we're going to do it. We clarify somewhere whatever number of days we talk about, whether in any places, either calendar or working days. And, but a failure to issue the notice doesn't invalidate the
good,
action.
very good point.
In the last sentence, is that where we should put the director shall mail notice to the permit holder and
Yeah.
the property owner? You get the property owner in there
Yes.
with all the fudging language you need to.
It's like landowner and tenant.
Are you saying in place of any persons or entity?
No, in addition.
In addition.
In addition to?
Yeah, so I mean, if the permit holder's a lessee, the notice would go also to the owner.
Right.
That's however, whatever language.
That the permit holder, the landowner and permit holder. In case it's a tenant.
Okay. So, moving to,
The simplest
Yeah.
3-sentence paragraph.
I know, which is taking 30 minutes. 1702-140 appeals. We do have an appeal section currently in our code. The current appeal sections actually stipulate that appeals have to be filed within a specified number of days. This section doesn't say that. Is that,
It says all appeal shall be filed in writing within
It's
15
in
days.
section time limit
Time
section
limits.
on the next page.
on the next page?
Yeah.
Yeah,
Wow, okay.
and that's,
15 days.
15 days, yeah, it's
Yeah.
currently 15 days.
before we get to that, on the rights of appeal, we don't define exactly what's meant by the last phrase, provided that the appellant has participated in the administrative process prior to filing an appeal. If somebody just appears during the public comment portion of the hearing, they could certainly argue that they've participated.
So standing is really broad when it comes to these, and so I would almost just leave the word participated, and people will fight about whether they have the standing or not, but if you're like, if you show up in public comment and you complain, there's an argument
Yeah.
that you have standing.
So you don't think we need to go into exactly what?
I don't know that we should.
Somehow, I never thought of standing as analogous to pornography, but what you're saying is standing.
So I didn't say it was analogous. I wasn't saying it was analogous.
I'm ready. I'm good. I'm getting, well, yeah, okay, now I'm getting down to it. Where the standard, the Supreme Court Justice once said, I can't define it, I know it when I see it, and this isn't it. So standing is the same sort of thing, is that you.
Just want to make it clear, the comments of Commissioner Ledbetter, this speaker, not necessarily the views of this speaker. Okay.
It's the Potter Stewart standard.
If somebody participates anonymously without identifying themselves at the podium, I'm just curious
Yeah.
about that.
Yeah.
Well, we have to know, I mean, if they don't identify, right, I
They don't
mean,
have standing.
I mean, we can argue, obviously,
I guess we go back to the film.
yeah.
Somebody could go back to the.
I mean, if Martha's aware of what other counties do with that, maybe she has some experience with how that's dealt with, if it's dealt with in more detail elsewhere. I just think people are gonna fight about standing, no matter what's put in
It's
there. And if
beyond
if we put something in there and it turns out a court thinks we're wrong and we defined it incorrectly, then we have attorney's fees with all of that, right? So all good.
Okay, okay.
Yeah, I do need to point out that I've come across, I'm gonna have to look at the appeal deadlines. There's some sections of government code that say that certain types of actions have to be appealed within 10 days. And so we're actually not allowed to give the 15 because we're not as strict as state law. So we're not allowed, we can't be, we have to be at least as strict. Yeah, it's the legislative intent was timely resolution. So I have to look at some of those. I had come across a couple where we
Okay.
may be more generous than state law allows for.
Back to my global comment. We don't know enough about that.
Yeah.
Yeah.
Leave it to you.
Yeah, but when we get to time limits, we've got a different situation now than before. Just saying that in the event the appeal period ends on a Saturday, Sunday, or any other day and the county is closed, doesn't cover things anymore. If say, what is it, Wednesdays, all day, the planning commission desk a planning department desk is closed to the public?
No, we're open.
Oh, what does the sign say there by the desk?
It's been removed.
Oh,
But that's a good point. I think he's using that as an example.
You know,
If our office hours change,
if maybe we should have something about, so that any other time that the applicable county office is closed to the public.
Well, this tells me that it's calendar days, but that the day is extended if that final day falls on a
Right,
day that the
right.
county is closed.
Yeah,
Right.
right, but it's a question of, the county may not be closed, but people can't
Right.
actually put in their, because the office is closed. So that's why I'd say any other
closed.
time that the applicable county office is closed to the public.
Do you have a submission box so that if you leave at 4, people can go till 5 to deposit something?
No, because it says the appeal period shall end at the close of the business.
Which is 5.
Right, well, no,
And-
which is 4.
4:30.
Is that?
Everybody closes at 4.
4:30, building, the doors are locked
But-
at 4:30.
No, our building closes at 4.
Our office hours are by ordinance somewhere. That's the thing. We have an ordinance and I think it might say 8 to 5. So we might want to have a drop off box where somebody, but you were saying the door would be locked to the entire building at
Yeah.
4?
But you have
Yeah.
a drop-off box, why then, if they don't actually put it there, where they could say, well, I put it there.
No, I
They
just
took-
thought it would
They
be
would find
maybe
it
in
on
the
the next
building.
floor.
I thought maybe the building would close at 5, even if the department closes earlier, and there could be a drop-off box, but
Yeah, the building department locks the door when they leave, and that's usually.
to the whole building.
Yes.
No, yeah, no, our doors automatically lock at 4 o'clock every day.
Okay.
The only way you can get into the department is with a
So we
fob.
need to check what our ordinance says about
Yes.
county office
Or we
hours.
can we put a reference there to whatever the ordinance says?
Well, we-
In case it changes in the future.
But we still could have the situation where, say, building permits, that
Right.
desk is closed to the public at some other time, other than what the county, or that's why I was suggesting the language I was suggesting, which I'm not wed to the language, but just the concept that if somebody can't turn in an application, it should go to the next day.
Because the office is closed.
The
Even
office
if
is
the
closed.
entire, because
Or-
this says the entire county
Yeah.
complex is closed. Are there occasions when the
Yeah.
planning department
Well,
is closed and the
or-
county is not
I
closed?
think-
Or if it falls on a holiday, I think we can make adjustments for those kinds of
Well,
things.
that's
Well,
easy.
that's covered
That's
here.
easy. It's if, say, say there was a department, which there used to be, that is not available to the public for, say, Wednesday afternoons.
Right. Hypothetically.
Then, yes, hypothetically, then the person should have his time extended to the
Absolutely.
next
And we,
day.
oh, yeah, definitely.
So that's
we
why I
would.
think
So
we
should
need
it
to have
say
that
the
whether.
county or the planning department offices are closed?
We would normally do that
The
anyway.
appeal period
Close-
and on the close of business.
I would say closed to the public, because there might be people working back there in the office,
Um,
but not
Okay,
receiving. In case somebody changes.
I'm gonna leave that. You
Yes,
guys get the issue.
Oh, yeah.
In
It-
case the policy
Martha.
changes sometime in the future.
Yeah.
Martha's nodding, and that's enough for me.
Yeah, we would accommodate something like that.
Okay.
We don't want to talk anymore on it.
That's right, exactly.
Okay. Are we ready to look at procedures?
Well, yes. Well, and the only thing I have there is that under 3, that on the second line, it just needs the word "the county clerk."
And I had on item 3, and who knows what I was thinking. The director shall also prepare a staff report that responds to the issues raised by the appeal and may include a recommendation for action by the PC or Board of Supervisors. It sounds like the director is recommending the action.
Oh, I thought he is.
But the recommendations may have come from the planning commission or the board of supervisors. He's just
Oh,
transmitting them. Or he might be coming up with a Zoom, but probably not if it's an appeal situation.
Yeah, I see what you mean.
Sorry, where are we right now?
The transmission of record
So what was your suggested change?
was just to, at the very end, to say, which may include a recommendation for action by the planning commission or board of supervisors.
But I think that's already implied, though, if you look at the second line at the top, consideration by the authorized hearing body. So whatever the transmission, whatever the planning director is transmitting is basically a record of a hearing that's already taken place by the authorized body, and the director is not making those.
Is to the next body.
How
So,
about-
yeah.
How about
So
just say,
two.
how about a recommendation of the hearing body for action? But we've already talked about the constitute the record to the hearing body.
Yeah, it wouldn't be to the Board of Supervisors because it would be going to them
Right.
from the previous. So maybe it's fine to leave it and it's sort of,
I think it's okay the way it is.
yeah, that constitute the record to the hearing body. Okay. I think it's not.
Then in E, I know this is implied, but the second sentence says, no relevant facts that were known or could have reasonably known to the party raising them at the time of the decision being challenged was made or shall be considered at the appeal hearing, but we don't specifically say if they were not presented below. So no relevant facts.
Well, if you read the following sentence,
Yeah, I
though,
think it makes
doesn't that
sense in
clarify
context.
what you were talking about, Mr. Commissioner?
Yeah.
If the new relevant factual information is presented on appeal that could not have reasonably been not known at the time the decision being challenged was made,
Well,
does that not satisfy your?
I mean, I certainly understand what
Yeah.
we're trying to say. It was
Right.
just a thought maybe somewhere we ought to actually say, and these were not presented below.
Right,
That just isn't a part of
Well, it says that
It
in the
says
second
that
sentence.
yeah, that's what I was referring to.
Says no relevant facts
Okay.
that were known or could have reasonably been known to the party raising them at the time the decision being challenged was made shall be considered at the next.
Well,
Right.
okay, if nobody else sees any need, that's fine. It's just that we don't specifically say that they weren't presented below.
I think it's fine.
Okay, that's great.
Yeah, okay,
That's good enough for me, Julie.
good enough for me.
So zoning clearance, you there?
Yeah.
Do we need, in section 020, applicability, do we need to include reference to signs in this list in the first sentence? Zoning clearance is required for buildings or structures erected, constructed, altered, repaired, removed, the use of vacant land, changes in use of land or building. Do we need signs not otherwise accepted?
Can I go back a little bit
Sure.
to G? For public notice and hearing, I just wanted to, we say that notice of hearing shall also be given to the applicant and party filing the appeal and any other interested person who has filed with the county clerk a written request for such notice. So
Where are you?
She's going back.
I
I'm
know.
going back to G.
Page 19.
Page 19.
19G.
So under state law, when it comes to these notice lists, there is an expiration date. For example, if you ask to be put on a list, that, we don't, it can get so big over many years. The state has been kind enough to provide that you have to renew your request to stay on the list. So I don't know whether the intent here is for us to do more than state law requires, or we should just
We
say,
shouldn't.
Currently effective.
notice of the hearing shall also be given to, and the applicant, party filing the appeal, and any other interested person who has submitted a request
Can't you just
for
say?
such notice as required by state law.
Okay.
I would just add as required by state law after the notice.
Well, that sounds like the request was required by state law. How about just a person who has filed with the county clerk a currently effective written request for such notice?
The currently effective, I mean, we probably want to reference state law.
I think such notice, means that they're not just asking to be on the planning commission's overall list of what's coming up, but specific to this
Yeah,
particular action.
right, but what Julie's raising is the,
Yeah.
We
Time
have
limit.
people who will say, I want notice of all planning commission.
Yes.
Yeah, and
Right.
it goes on and on.
But then there's those notices that, those written requests that say, I want to be noticed for all,
Purposes. Yeah.
well, for all, landfill, public notices regarding landfills.
but
But
that's,
some people, I mean, 50 years
Oh.
later, the requesters are dead, and we're not required to do it forever, is all I'm saying.
Yeah.
So we might, under state law, so we could do 2 sentences. Notice that the hearing should also be given to applicant and party filing the appeal. Notice shall also be given pursuant to state law to any other interested person who has filed a written request. Just do it as a separate
That would be
sentence.
fine.
Yeah.
Yeah.
Okay, say the second sentence again. Appeal period.
Party filing appeal.
Notice of
and then you-
hearing should also be given
So
to-
after appeal, you
Right.
end the sentence and then you do
What's
exactly
the-
what Julie said.
Well, that's what I'm asking.
I'm
Can
going
you
to try
slow
to
down?
reiterate it. Notice shall also be provided pursuant to state law to any other interested person who has filed with the county clerk a written request for such notice.
Yeah.
So what do we do now if somebody's somebody maybe who spoke at the original hearing and is asking to be kept up to date?
They should file a notice with the clerk saying, please give us, they should. If they participated as a party officially.
No, I'm talking about just someone who commented. But they specifically say to staff, can you keep me up to date on what
So,
happens with this? Do you tell them to go file with the county clerk?
No, so as a courtesy, we maintain an email list. Annette maintains an email list. It's got 700 plus email addresses on it.
Give you a
It
blast.
started through
But
the
that's
general.
generic, right?
Well, it's generic, but they receive notices of everything that we post on the, so if we're posting a notice, whether it's, an upcoming agenda or,
So the question is whether you want to keep doing that regardless of whether you can cancel some of those names after a year. Do you want the right to cancel some of the people on that list, or do you want to just
do
keep
we
it
really
going?
want? I mean,
There is no mechanism to receive only a response to a particular agenda item, because that would be, how would you ever manage that, right?
right.
So it's, you just add them to that
So this
list.
is, this
Oh.
kind of covers everything.
And
The
so-
way we do it now just kind of covers everything.
You can do more as a courtesy whenever you want, I guess. What you
Right.
should ask.
And it's not a big deal. I mean, because we don't even put those people, there's a spot on the planning page, on the planning page of the county website that they go in and actually enter their information. So
Okay.
we can,
Which
they can be
I
on
do.
this list.
Yeah, I receive.
And
those.
and you can
Received them
keep
for
doing
years.
that.
Yeah.
As a courtesy, the question is, do we want to be required by ordinance to be doing that when?
well, by this one, this section only covers the particular appeal. Now, maybe our mechanisms
Yeah.
are to tell everybody, but, this doesn't have to provide for everybody.
Right, so I think what Julie is saying is, are we gonna have somebody complain, I didn't get the notice about this item? Well, they did, but the notice was so generic, they didn't realize their item was gonna be in it. And that's what I see is people tend to ignore those because they don't know that it's gonna apply to them. And this might give them the impression that they are going to get a more individualized
Right.
notice that an impression we don't want to give.
But it's a policy call.
Well, I like the idea that we should have a time limit on when we give those notices. It shouldn't be in perpetuity, 24 months, 36 months or something. After about 3 years, I think we should say, okay, we're not
Well,
giving.
I have an
or
But
idea.
some-
again, we're talking
have an
about an
idea.
appeal.
I have, why, so after adding
So-
that second sentence, why don't we say at the end, or say after that, any additional notice provided by the planning department shall be done as a courtesy? So that you can have a policy to do it, but you're not in trouble if you fail to do more or than is required by state law.
And I think
fine.
maybe we should change the sentence to say other interested persons may sign up on the planning department's website to receive,
Courtesy notice.
no, notices of all planning department agendas.
That's,
So something like that, so they understand they're not watching for something that says there's an appeal coming up on this item.
well, what would the notice say?
Specific. It would just say there's new documents posted to the county's website, and you go through and you read the agenda.
Oh,
There's a new agenda posted on the,
Which I also don't know, that's not required necessarily by state law.
well, then we
It's
should
on
take
forever.
out anything saying that interested parties can sign up and make that a global thing. Interested parties can sign up on what,
So what I would recommend is in your code, kind of keep it as clean and with the required. Other things as far as a courtesy, or you can also check the website. You could always just do an FAQ or like something that is actually more accessible to people, separate from the code. Because Julie is right, there's a certain amount that's required per state law, but you can do all other types and forms of noticing. So I would recommend you do Julie's suggestion and have, notice of the hearing shall be given to the applicant and the party filing the appeal, period. Notice shall also be given pursuant to state law to other interested parties who have signed, have filed a written request. Because I do believe state law does say you do have to provide notice to people who have put a request in writing. With other components, I would put as a step, kind of do a separate FAQ or policy and procedure type of thing.
Yeah,
right?
I
well,
agree.
that sounds good, but I am concerned about the notice being given under this section needs to be specific enough so that people would recognize what's,
Well, it is.
If they're
for
asking for the
parties.
notice, then they should be reading what's being sent to them.
yeah,
There's a certain level
If
of
it's-
personal responsibility.
yeah.
I don't think that's gonna happen. I think,
I don't think we should hold everybody's hand, sorry.
yeah.
You're asking me for a notice, you better read it if I send it to you.
What notice would somebody
They need to tell them how
receive?
to request that notice and what they can expect in
And that
return.
can be done on a website too.
Could be,
I don't think
yeah.
that has to
Or
be
it
an
could be a
ordinance.
No.
phone call, or it
This-
could be a letter. I mean, we
I'm
can't,
just-
somebody's gotta reach out. If they wanna get noticed, they're gonna have to reach out.
No, that's-
Everybody's got a
that's great.
phone number.
That's great, but
They've
assume
got
that
a counter.
we and they have followed state law and they've requested notice,
Okay,
such notice, it says here, which I would think would be a notice of action, and that notice somehow has to be specific enough so that they, okay, that,
It
What-
won't to other interested parties. It won't. They,
well, I think we're talking about two different
yeah,
things.
I think so too.
I mean, if we're talking about a specific project.
Yeah.
Appeal,
right,
and somebody wants to be noticed
yeah,
for that project, then there's gonna be we're gonna have a notice in that project file that includes this name and address on our list of notification.
and when they receive that notice, it's gonna be clear
It's
that
gonna be very
this action.
specific.
It's very.
Yeah, it's a
Oh, okay.
specific
That's
notice.
great.
Are you going to have, how would you?
We do that now. I mean, we've got a general email
Yeah, I
list
understand.
for everybody that wants to see everything that we're doing.
Right.
But then if there's something specific to a project that we're working on, we maintain a separate mailing address list.
Yes.
But we're not required
Required
to
to-
do
yeah,
that.
that's the
I think
point.
that's the concern is,
I don't, we are.
Well, that's,
only to the parties
So
to
all
it,
we're
or the
saying
people
here-
within the.
All we're doing here, because there's different state law requirements for different types of lists. All we're saying here is that as far as who shall absolutely get notice, you know, regardless of whether you have a policy to be more helpful or not, the people who have to get notice legally would be the appellant, the applicant, the appellant, and anybody who has a state law right to get the notice.
Right.
And that what Martha's saying is that the extra stuff you do to be helpful should be
Not here.
not in there.
Right.
yeah, that's fine. I just wanted to.
You can
make-
still do it.
Yeah.
And you're right, Gina, there do have to be those lists. The issue is what I don't think has been implemented by planning is that those, so when you hear me say, okay, we got a request that came to me instead of to you, put this person on the list. Okay, what I'm saying is, yeah, you do have to do those lists, but they don't have to go on forever. There's expiration dates, and so the only reason we're
But the
citing.
project itself doesn't go on
No, she's
forever.
talking about that general, that there's
Oh.
700 people list.
I don't think that's what this is.
No, that is.
No,
what we're
that's
done.
not, that's not what I think somebody's
No.
reading here, but I think what somebody's reading here, so if you're saying you do keep a list of anybody who has contacted you about a particular
Right.
project,
Right,
and you do give individual notice to them,
yes.
but that's not required by state law. So we need to distinguish between what's required by state law and what you're just doing.
No, I
We
do
don't wanna
believe it
promise
is.
that in here.
Well, I thought, what is required by state?
Well, I don't know all the different things for the different notes. CEQA has some requirements, and there's a variety of different types
So what
of
you're.
lists.
yeah.
There's
So
Native
your
American
language is
tribal
if
notice.
required by state law.
I just wanted,
Yeah,
so
do it.
I was just hoping we would do a generic, whoever's
Yeah.
essentially required by state law.
Yeah.
So if it's a CEQA involved project, that might include whoever.
So if it just said as
Yeah.
required by state law.
Right.
Okay.
Yeah,
And you could continue to do what you do, which is
Exactly.
above and beyond.
Yeah.
Okay,
Okay.
turn the page.
Which one?
We could be,
Applicability we're talking about.
yeah.
did we get to indemnification yet, or it might be?
No, we're
not there.
at
I don't know what happened to that.
1703020.
What happened to one?
Applicability
Oh,
and zoning clearance.
I have to bring something up, because there used to be a 1702160 in the original draft. And that's called indemnification. It was for whatever
Right.
reason taken out. I know our office is going, to the extent the planning commission doesn't want that in there, our office will be campaigning hard for it with the board of supervisors.
I think
Since it isn't in here, I had no position on it, so.
So.
Well, it doesn't belong under appeals though.
Oh, okay.
Indemnification's a more global.
Right.
I think it was taken out of here, but I don't remember seeing if it was it put back in anywhere, Martha?
Yeah, I'm sure it is.
Because I don't remember seeing it
is
put back in.
somewhere.
I've seen.
Because it's part of the applications process.
That's what I thought.
Right.
So it was in the it was somewhere in the,
It's right here, Julie.
I can't see across the room. Oh, okay. Sorry. I had a note in here because I think at one point I didn't see it somewhere.
I think
Sorry.
there was more detail about indemnification and
Okay.
instead of having conflicting pieces.
I got it.
Yeah.
Sorry, guys.
It's all right.
All right.
One more time. 1703020
So
applicability.
I've been reminded that you don't need to list signs in here because they are structures.
Well, because they're not always, right? Sometimes they're attached to a structure.
That's what I was wondering. Okay, so what I was suggesting, if you want an exhaustive list for zoning clearances, if you want to require it for signs, we ought to list it as signs not otherwise accepted.
Yeah.
Okay, so as I understand it, the zoning clearance procedure is for people that it's clear to them that what they're doing is consistent with the zoning. They just want a clearance and a rubber stamp from the county that it is consistent. And that's why we have this language, which are allowed as a matter of right by this title.
I'm wondering if it's too broad though, because do you really want to have a separate process of a zoning clearance for re-roofing, kitchen remodels? And it says altered, repaired, or moved.
Mm-hmm.
And it seems like you're,
Now, would this be taken care of by the pre-application procedures that we've been adding?
No,
no.
Okay.
I mean, it does
These
say well, the purpose statement says it's for new or expanded uses. So we could, I don't know if there's a way.
should we reiterate that these are,
How does this change from our current? Do we have a zoning clearance?
No, we use the
we don't,
business license.
we don't have a zoning clearance section, but we've pretty much been performing this action already.
Yeah.
It's anytime we look at an ABC license, application.
Business
An
license.
application for a business license, an application for a building permit, a grading permit.
And there's an internal county routing process from all of these departments.
Yeah, the new or expanded use that does sort of take out, even though it says alterations down here, that would imply more major alterations that change, create a new or expanded use.
But that's just in the purpose that isn't
Yeah.
enacting
I think that's
requirements.
true. I think it's having it just in the purpose. Lawyers will say, well, that's just in the purpose statement. It's not really the law.
Right, right.
Yeah. So I just started thinking about it as all those little projects that happen on single-family residences or in small businesses that really there's no zoning applicability, really, nothing to check.
Mm-hmm.
So, and Gina can kind of weigh in on the current process. The idea is really, you know, as the building permit, say, gets routed to planning, or even the, you know, building saying, hey, planning, do you need to look at this? I have a re-roof or, you know, something. It's really to capture that, which, you know, it's planning's review. And so, and the clearance can just be planning sign off in that permit tracking system. You could adjust your fee structure to reflect kind of minor type, you know, you could have a zoning clearance minor fee and a zoning clearance major. We could also just put kind of a general waiver provision in here that the planning, you know, director may waive the requirement for zoning clearance for things that don't involve any kind of, well, first of all, I guess we can exempt repair and maintenance.
Yeah, maintenance, repairs, and maybe interior remodeling that doesn't change the use or
Yeah.
intensity, something like that.
Use or occupancy or
Exception.
something.
I mean, it says not subject to any building or zoning regulations, but it's talking about entire uses and buildings, and that's not.
Yeah, so you could have something that would require a building permit, but
Yeah,
it wouldn't be subject to the zoning clearance. is
yeah,
what you're
like
saying.
a bathroom remodel doesn't,
Yeah,
yeah, exactly. Gina's gonna be, why are you here? So maybe just another category of exceptions to capture those things that Gina doesn't want to see come over the desk.
yeah, under applicability.
Yeah.
Good. We'll clean up the purpose statement.
I go down to 040B. and it's just the sentence that starts down by the end of the page. Prior to issuing any building permit, subdivision approval, or lot line adjustment, the director shall review. Since the director doesn't issue the building permit, I'd say we have prior to the issuance of any building permit.
Can we say anything about subdivision approvals here? I guess we could just keep
Oh,
it
this
in there.
very last sentence, yeah,
Yeah,
prior to issuing any building permit.
right.
Or so prior to the issuance
Yeah,
of
the
any
issuance
building
of-
permit, blah,
that's
blah,
it.
blah.
Exactly.
Yeah.
Why is the issuance better than issuing?
Because
This
prior
looks
to
like he's
issuing any building
issuing-
permit, sounds like the planning director is the one that issues the building.
Oh,
Yeah.
right.
Yeah.
But do we include subdivision approval, given that subdivisions are under Title 16?
Well, that's a good question.
I mean, I think you'd be looking at this anyway, because the subdivision application is gonna be.
Yeah, that's gonna
a
come to- I
discretionary
think it's okay
approval.
to have it in there, because
Well, yeah.
planning's going to be involved in
Because
those
I think the
things.
zoning clearance includes conditions of approval of a, which could be, in fact, a subdivision approval.
Yeah, just clarifying who.
Brad, I'm sorry, the bottom of that page, 21. Do we want to say, right at the very end of the last line, say the proposed use? Determine whether the proposed use, building, or change in lot configuration applies with all provisions. Not necessary, but clarifying.
I like it.
I just thought it would be obvious.
Yes. Well, I seem to be the champion. of
It
the
comes
obvious.
up a lot, the whole proposed versus just stating
There's
it.
been prior conversations on that.
Yeah. No, it's just that, you know, we're trying to make this as user-friendly as possible, and so sometimes I think I over clarify.
Okay, design review.
Design
Are we
review,
ready?
yeah, I go down to 030A.
Hector has something highlighted, so we're gonna let him talk first.
Well, actually, you know what it is? I'm glad you mentioned it. I learned so much by this document than I have in all the other meetings. And so, of course, I highlighted the obvious. You know, the design review establishes the design review for procedure, objective for the general plan. I mean, I just took the very basic fundamental purpose of each section, and that's where I was able to actually become enlightened.
Understand.
About the functions of the planning commission.
This is what we're doing.
So, yeah, we can go over my highlights, but they're gonna be like very obvious. By no means will it be as meticulous as yours.
All right, Hector.
Okay, so under 030A, I think otherwise, the word otherwise is a little unclear. So the planning commission shall have design review authority for all projects that would require planning commission approval outside of a design review overlay zone. Is that the meaning we meant by otherwise?
I think.
Yeah,
that
so if
there's a
you-
C-
Go
Go ahead, Martha.
So yeah, if there's a CUP required in the planning commission for a project and it's in the design review overlay, the planning commission would conduct design review. If it's a project that say doesn't require a CUP, but it is in the design review overlay, the director is gonna conduct design review.
So,
Or it could be a variance, it could be any other discretionary.
Right.
right, so I just think having language in there that clarifies what you mean by otherwise is a good idea.
Do we need otherwise? We probably don't, right?
I think he wants it to say, design review authority for all projects requiring planning commission approval of a discretionary permit or something like
Yeah,
that, right?
or-
You
or
want to
just-
describe why.
Or commission approval outside of the design review overlay zone. I mean, if this is the sort of thing we look at outside of the design review overlay zone, we will be looking at it inside the design review.
Now I'm more confused.
Okay, anyhow, if
We'll leave that.
nobody else is puzzled by the word otherwise, I'm fine.
It's really just that they have a discretionary action required beyond design review. Outside.
Outside the design review zone, yes, exactly.
So what's the consensus? Are we leaving otherwise?
I think it could use some clarification.
What is the intent of that word, Mark?
She just explained, so, if we have a project that requires a conditional use permit and perhaps also a design review, the conditional use permit, the design review of the project would then be considered with the conditional use permit, therefore by the planning commission. Otherwise, absent the conditional use permit, it would just be under the authority of the director.
Yep, that's what I was trying to clarify.
So instead of the director reviewing the design review component of a project and then kicking up the use permit to the planning commission, they would consider everything, including the design review.
Because this is compounded by the subsection B, director, the director shall have design review authority for all projects that do not meet the criteria. Well, what are the criteria? Well, the criteria are otherwise.
Yeah, it made authority for all projects requiring planning commission approval. In
For
addition
discretion.
to design review. I mean, it's without listing them all.
Oh, yeah, well, that's what I'm just saying, that would require planning commission approval outside of a
Well,
design
it's
review.
regardless of the design review.
Okay,
Yeah,
sure.
or some
Yeah.
word that,
Yeah, but no, that's good, regardless of design review.
or irregardless.
Oh.
No. Yeah.
How many angels are dancing on this head
Yeah,
of this pin?
exactly.
Okay, is that,
We'll let you guys look at the wording. It's just, it seems a little circular here.
yeah, and it's just that then when we cite criteria under B1, we really don't state criteria. I don't know, we haven't heard a got it there, so I'm,
Well, I think the hard part is kind of, any of these kind of revisions don't seem any clearer. So we'll see what we can do. I mean, whether, if we take out criteria, it's basically requirement. Yeah, I mean, we'll work on it. It's just,
provide some
I
criteria.
feel like I can't give you a gotcha, I can give you a we'll work on it.
Okay,
So could we
That's
just
fair.
say for all projects requiring discretionary approvals by the planning commission in addition to design review?
in addition to, sounds like they might be doing both. And that she's going to be working on it.
Okay.
That's- I go over to public notice, subsection, let's see,
Where?
on page 24. Under section 040.
Yeah.
I don't understand why, if you have public notice for an administrative use permit, why wouldn't you have public notice for a design review?
I have the same comment.
Shouldn't the neighbors get public notice?
Yeah, we can clarify that. It should just be like you just get public notice, if the associated permit does too.
Okay,
So, yeah. So if you required an AUP, which gets notice, that notice would also include notice of the design review.
Okay.
and the design review always coupled with a AUP or a CUP?
No,
Not necessarily.
Okay, anyhow, I think we want to make sure that public notice is provided for a design review application.
Even if it's just by the director.
Yeah,
Yeah.
I think we
So-
typically provide public notices for all the direct discretionary actions that we take. I think
Yeah,
it's one
but
of
I-
those inferred assumptions.
Well, this says no public notice
well, we
is
don't.
required. That's what.
Administrative applications don't get public notice.
AUPs?
AUPs do.
No, I
Public-
mean, I guess
have?
it depends on
Yeah,
what you
they
mean.
do.
Public notice in the form of a formal public notice. I mean, we do send them notice of application.
But, I mean, on
Within
page
300
26,
feet.
we have requirements for public notice with
Yeah.
AUPs.
We send notices.
But I don't think it's, okay, well, I
I
don't
mean-
think we've actually referred to them as public notices.
So depend,
Well, that's what they are.
aside from how we define the public.
So it's not notice
what
of
else?
hearing, right? It's not
No,
like
because it
public
doesn't
notice
go
of
to a hearing.
But
It's a notice of the application.
yeah, I don't know what your internal processes are, but we are supposed to give notice
Yeah,
of
we do.
AUPs.
Yeah, I mean, and
We do.
and that's what's on page 26. 040B says, all applications for administrative use permits require public notice pursuant to the section that provides public notice. I just think that we could have exactly the same
For a design review.
for design review.
Yeah, I mean, it
Yeah,
goes,
I would think your neighbors would need to
it
get
goes
public
without saying.
notice for
Yeah.
design review.
Yeah.
Okay?
well, I guess I would just stay with that, and it's because I'm not familiar with your design review standards in the Colony Hill. If you're providing notice, does that identify what gets design review? If somebody's doing it in addition to their house in the rear of the property, do you notice that? That might be something, the design review is the director is just like, well, no one can see it. So I'm signing off this design review.
So in Oak Hill, there has been a public hearing for design review in the past.
Okay, maybe Gina, let's go kind of through this so I can understand a little bit.
Okay.
Yeah,
Whether or not there was something else going on.
I think that was under the PD,
Yeah.
because the new DR procedure, I think, brings it back to the planning director.
And I just need
I
general,
think this is just something to think about philosophically. If a community has decided that they want design review, right? And that's what it takes to have that added as an overlay. They're gonna be interested in being noticed about it.
Yeah, actually, I do believe that any actions that the county takes that are discretionary in nature should be notified to at least people within a specific radius or interested parties.
Yeah, it gives them the opportunity to file an appeal.
Yeah.
Amongst
Oh,
other
boy.
things, yeah.
Right.
so am I correct that the Moke Hill situation is under design review but not plan development?
Right, so, all the
Or it will be.
properties, all the properties previously, designated with a PD overlay were basically rezoned to a DR, design review, when Peter was here, and then we approved a new section of code relative to design review. And so everything within the historic district that is designated with a DR overlay has to comply with the design guidelines adopted for the McCollum Hill community.
Okay, yeah, I was just unclear
There
as
would
to,
Yeah.
not necessarily
Under-
need to be a public hearing, even if there's noticing.
Right.
That just gives people the opportunity to look.
Right, so it's
Sure.
not that we're coming to a public hearing before you, it is a process that is within our department, the decisions made by the planning director. Without looking at it, I'm assuming we do currently provide some sort of notice.
So I'm correct then, and as far as the Moke Hill concerns about historic validity and all that stuff, under this revised zoning code, it will come under the design review, but not plan development, correct?
Right,
Okay.
So-
I just needed to get my,
yeah, so plan development is now, we've separated the design review kind of component of current plan development. So going forward, if adopted as drafted, then the plan development overlay will be a true traditional planned unit development. And anything relative to design will then roll to a design review or DR option,
So some-
assuming that there's design guidelines approved for the community.
so some future subdivision could come under both, depending on what.
Sure, if they want to
Have the
regulate the design of the subdivision, they
Yeah.
could in fact impose a DR,
Yeah.
combining zone
Uh-huh.
with adopted guidelines, of course, that have to be approved by the board.
But they probably wouldn't, they would
No.
do internally it through their
Right.
homeowners association.
Yeah.
That would probably be more appropriate. I mean,
Yeah.
I think the term community, we're kind of tying this to a community area. So, it would probably be more likely, as Michelle's
Yeah.
indicated, through the CCNRs rather than,
Sure.
I'm sorry, I looked up our code and I just have to tell you, like, our AUP procedure right now does not require neighbor notice. Right, our existing. It's
Yeah.
only for planning commission or board approvals.
Yeah, but,
I'm just saying.
yeah, but the
But the
proposed,
new proposed one does.
Does,
Does.
just,
Yeah.
just want, Gina's right, if we
Thank you.
haven't been doing it, the ordinance
Yeah.
doesn't.
Yeah.
I actually think that the change is good because that is a complaint we hear all the time is I didn't know about it and it's happening right
Yeah.
next door to
Right.
me.
I just wanted to
Yes.
validate what Gina was
No.
saying.
thank you.
Yeah.
Okay, I'd go down to 050.
So I just want to check with everybody. I'm thinking we get through the design review section and should we take a
Take a
lunch
break?
break there or should we try to get through AUP also to shorten our afternoon a little bit?
Let's just see
let's
where we are.
get
when we
through design review and then see how quickly we can get through
Well,
that.
I'm just trying to figure if people
Yeah.
want an earlier or a later lunch.
Yeah, that'd be fine.
I prefer an earlier
Me
lunch,
too.
but that's just me.
Okay,
Okay,
let's do it that
so
way.
let's do that.
Let's,
And then
let's
I
let you dictate
I
something.
also
Okay.
want to ask people
Thank you.
what time they are comfortable with ending today. Because we could be here as late as we like.
Yeah, I think that depends on just how exhausted we get.
Yeah.
I don't have
If we
any,
start to get grouchy,
I don't, yeah.
Well, we're already there.
well, I have to say, I'm challenged with some new glasses, and so if I'm not looking at you, it's because it's making me sick. So, I mean, I'm getting a headache as we're going on, just because I'm
Then
things are
maybe
disordered.
you should let us know.
Yeah,
So much for the eye
I don't think
appointment.
I'm trying to be rude if I'm not looking at you. I can't look at you because it's just
So,
making me ill.
I would like to say that we should end by 4, but if we need to end earlier because anybody's feeling overextended,
Yes.
that's okay too.
Yeah. that's
Okay,
right.
all right.
Okay,
So let's just try to get through
we're gonna get through design review.
Design review,
and,
okay.
Yeah.
So we're on 050, scope of
050.
design review?
Yes, we're
right?
starting 050.
And do we want to, under A and the introductory thing, do we want to say including but not limited to these? Are there other design review considerations that we want to be possibly considered?
Sure.
Okay, including but not limited to then? And that's all I have.
Okay. So I was interested in why single-family residences have color accepted. I mean, I understand why. But you want color to be reviewed for any other project? And I'm just like, who decides what's an appropriate color?
Well, that would be written into the design guidelines.
But that single-family residences would not be?
I mean, you have one person in Moke Hill that wants to paint their house raspberry, that's,
Oh, I'm sure that they would have something to say about that.
well, something to say about.
Actually, color was not included, even though at one time in Moke Hill, they asked to see the colors, but then it turned out the color was not covered,
Yeah.
right?
But I suppose some community might want to include color.
Well, I'm just thinking
Right.
maybe, why are we exempting single-family
Yeah.
residences?
Yeah.
If a community is wanting to review things, then
Let's let them do it.
I just
And-
want to know
and
what's
if-
wrong with raspberry. I don't know. As a house color.
I think it's a philosophical question about whether you tell people what color things can be, but when I imagine that this would be a smallish community that has decided that they're going to regulate themselves, are they likely to think that color shouldn't be regulated?
Right.
You know what you could do, and this is particularly because of the fact that for any of those communities or areas you'll have this, you're gonna be adopting through a community process the guidelines or criteria. So what we could do is actually take out 1 through 7 and just say design review shall be based on considerations and requirement of the chapter as they relate to the design, and consistent with the adopted, design criteria, or something to make reference to that community adopted guideline or criteria packet.
Well, I like having these discretionary examples. I think if I were, as a member of the planning commission confronted with a design review thing, this does give some sort of structure as to what I may be considering. I mean, you're not requiring.
Well, a technical question under 050A2, would landscaping be included in that definition?
It says so. As they apply to the design of the site plan structures, landscaping, and other physical features of a proposed project.
And there's a landscaping
And
under
then
6.
6 says location and type of landscaping, including selection and size of
Okay.
plant materials. And I think having an idea, I think if it just said exterior materials as they relate to each other, it just took out that exception. And then, but I do think it should also reference the adopted standards specific, just like you suggested, Martha.
Okay.
So we want to take out, except in the case of a single-family residence.
I might even take color
Color
out
out.
and just leave it at exterior materials and people can,
Okay.
that the individual community can decide if color is part of that.
Okay.
I just misspoke, and that this really does say you shall consider these things. So it's not that we could consider design review without looking at building proportions.
Right.
But I think it's a good idea to have a framework.
Okay.
That's all I have for design.
Me too. I thought this would take us longer. I thought
Well, we can go for another 20 minutes.
well, the thing is, we don't have an actual design review any place besides Smoke Hill, and it's already figured out, so.
Yeah.
So do we want to go a little longer and see if we can get through administrative use permits? I don't have a whole lot there.
Well, we can go a little longer, but
You want to go to 11:30?
yeah.
Can we get it done in the next?
Well, I think we might be
10
able to.
minutes.
Let's see.
Okay, my first actually, I have a comment on 010. I think this is a good statement of purpose. I imagine you've got things highlighted there too.
Mine is just understanding.
Yes, anyhow, I think it's a well done deal. Applicability, 020. Approval of an administrative use permit is required for uses or developments specifically identified in subsection 2. And do we want to say specifically identified as requiring such a permit? Or the uses or developments specifically identified for administrative use permits in subsection 2? Or do
It
you think
says
that's
which requires an administrative use permit. I feel like it's clear.
identified as good enough? Okay. This is a big one now. Let's take us to 11:30. 040 procedures, C. Second line from the bottom on
Oh,
page
wait, I
26.
have something on review authority.
Okay,
We're 1705-030 review authority.
Okay.
page 26.
It says that a project that may generate substantial public controversy can be turned over to the planning commission for a decision. In that case, the application shall be processed as a conditional use permit. And I question whether that's really it. I think it's fine for the director to decide something should be reviewed by the planning commission. I just think it still needs to be processed as an administrative use permit, and they should only be charged for an administrative use permit, and their timing shouldn't be extended dramatically. So I'm just concerned about upping the ante for somebody
that's it.
when they read that they should be eligible for administrative use permit.
But on some circumstances, I mean, I agree with your concern.
Me too. I agree that the director could say, I'd like to refer this to the planning commission for review.
And perhaps we can just take this sentence out then, because we already said you can just refer it to the planning commission for decision.
Sure,
But what are we taking out?
just the last sentence.
I mean, that, it just, oh, okay, in that case.
In
yeah.
that case,
Got it.
yeah.
Okay, my big deal. Second line from the bottom, 040C, directors needs an apostrophe.
So let's talk about that.
And the apostrophe should be between the R.
Yeah, well, thank you. Except after C. And 050, now there are several sections in this proposed change that are similar. To me, the first sentence says everything that needs to be said. The second sentence is less clear and is unnecessary, my way of thinking. The review authority must make all the following findings to approve or conditionally approve administrative use permit application. To me, that's perfectly clear, and you've got to meet all these.
Okay.
Then you're restating it, but less clearly in the second sentence, and I don't think you need that.
I agree. So I think that that is grammatically correct, but I think that there has been angst on the part of lots of people in the past when it feels like, well, I really want to make this decision despite the fact that I can't make one finding. And
I agree
it
with
should probably stay.
Oh, really?
I agree with Michelle on that, but I'm not on the planning commission.
Well, if you say the inability to make one or more of the findings is ground, well, it should be ground, not grounds, for denial of an application, that sounds like there might be some, some discretion there. That
No, I think
it's
it's
ground, well, let's find out whether it's, or you could say the inability to make one or more of the findings.
Shall result in
Shall-
denial.
Denial of
shall
an
result in
application.
it, yeah.
I agree.
Okay, we got it.
So what do we agree on?
Instead
I
of.
got it.
Instead of is ground, the second sentence, instead of is grounds for is shall result in.
Denial of an
Denial.
application. And we should remember that for the CUP section.
Oh, yeah, there's several like that.
I have that marked as a global change.
Thank
Okay.
you.
Global change. It isn't warming. Okay. Then under B, under C, one thing that the word adverse should be adverse with a D. Adverse is a,
An aversion to.
yes. It's a strong dislike. It is. With many of these, do we want to say, since we're looking for administrative use permit, which means it's a somewhat special case, do we want to say the proposed use will not be unreasonably or significantly or something of that sort, adverse? Or do we want to say shall be compatible with the public health? It seems to me there wouldn't be an issue if there wouldn't be this application unless there was some issue about it's going to affect some neighbors or something. If you have to have a finding that it will not be adverse to the public health, safety, or general welfare.
But that's pretty standard. I mean,
Yeah,
we
that's-
make those findings throughout all of our actions.
Because we need to, that's the whole, the police power says we can do zoning based on our concern for public health, safety, and
Yeah.
welfare.
Right.
Sort of a package.
Well, but concern for doesn't necessarily mean that there's not going to be a little shading here and there. I'm open to
Yeah,
suggestions.
and it seems like it should say the proposed use will not result in significant detrimental effects to the public health, safety, or general, or something along those lines, and then it's.
But significant gets real
Yeah, I
fuzzy.
know, I understand, but there's
Technically-
no way that an AUP for, say, an event won't have any effect
Right.
on the people right there, so it
Exactly.
seems like,
I point out that when we get around to temporary use permits, 040A, on page 31 says the proposed use will not unreasonably affect adjacent properties. You know, so that we have an example within here that there is a little room for fudging, but I think what the chair is suggesting would be just great.
Yeah, I just think it's the effects that we're talking about too, not shall not be adverse to.
Can you say adversely affect the public?
Yeah, that would be okay. Will not adversely affect the public health, safety, or general welfare, but I still think we need some
Edge words.
shading
Yes.
of that to allow for.
I think so.
Substantial, well,
Substantially. Significantly. Significant is a term used in CEQA all the time.
Yeah. This is,
well, the community, I mean, I honestly really like will not adversely affect, I mean, general welfare of the community, that doesn't mean a single neighbor. The
Right.
community is
Yeah.
like multiple people. I
Nor-
agree with
okay.
Gina that this is like very
then-
standard.
But then look at the next
it should
phrase,
be-
nor detrimental to surrounding properties. So,
Maybe get rid of that. What, I mean, it should be based on the community. Do we need that second clause?
well, I think that,
yes.
I think, but significantly detrimental.
Well, I think it's kind of reeling it in. It's like, okay, well, you got the community and then you've got more specifically, you know, properties that are more, you know,
Yeah.
directly affected.
But if they're affected at all,
So nor be
Negatively.
significantly detrimental to surround, nor be significantly detrimental?
that'd be great with me.
I thought you didn't like the word significant.
Well, not in the first clause.
Okay,
I can pretty much, I think that sounds good. I think we'll probably hit it again when we see it in its final form.
so we're gonna leave it with, will not be adverse to the public health, blah, blah, blah.
No, I think adversely affects
Adversely
the
affect
public
Oh.
health.
Public health,
safety, or
So that, yeah, the
Adversely.
whole wording of the sentence needs a little,
Effect, okay.
nor be detrimental to the
Nor
surrounding
be
properties or
significantly
improvement.
detrimental.
Yeah, exactly.
Okay. Then in D, we have the last clause is unless waived or modified. I think we're going to just put an asterisk by that, so when we discuss waivers, remember that there's this reference here, because I have significant problems with waivers.
Yeah. I agree. I have lots of waiver comments.
Now, we have reached 11:30, but we're almost
Do you
done
have
with
much?
this.
I don't have
No,
much.
I don't have much.
From here, so why don't we finish up?
Okay. Conditions of approval. First sentence is very clear, first and second sentence is very clear, but I think we need to have something before the list of conditions. We need something like these conditions or restrictions may, colon, just to make it grammatically clear, ensure that.
Actually, I wondered if we could just take this sentence and put it to the end, because it's achieve the following outcomes.
That's exactly what I was thinking, that then that list makes sense, and then the review authority could be at the very end, separate
Yeah.
sentence.
Oh, okay. So achieve the following outcomes, colon,
Right.
ensure, blah, blah, blah. Yeah, no,
Okay.
that's great. Thank you, Martha.
Perfect.
And that's all I would have.
That's all I've got too.
So,
And we bid a fond adieu to our planning director. So
shall we return at 12:30 from lunch?
That
be
sounds
fine.
That works for everybody? Yes, so we're going to break for lunch and return at 12:30.
I know.
Okay, so,
Here she is.
There.
Sorry.
yeah.
Hello.
The planning commission is back in session, and we are gonna start at page 29, chapter 17.06, conditional use permits.
I think we can go pretty quickly on this because
A lot of it.
as long as, Martha, you keep track of what we did with administrative use permits.
We'll keep forwarding along all of those
Yeah,
changes that are applicable to
same
each
thing.
section.
Yeah, I don't have really,
that would take care of me.
yeah, I don't.
Tim, you're satisfied?
It's like, did I not read these pages? But I have little green ticks on it.
I'm sorry, I gotta give you a bad
No,
time.
no, I could come up with something.
Yep, sure you could. Let's keep moving.
We can do the easy stuff of my highlights.
I like this, I like that. Yeah. Yeah, I really don't think I have anything. So, should we move on to temporary
Temporary
use
uses?
permits? Or do you have anything? Okay, well, good.
Okay.
I just skipped ahead.
Yeah, and there's some similar provisions
Yes.
in temporary that we handled in AUPs that I assume you'll just track over.
Yes.
Mhm.
040, A, here's where
Yes,
the
the-
draft uses, the proposed use will not unreasonably affect adjacent properties. Should we also be down a couple of lines where it's saying will not in any other way constitute a nuisance or be detrimental? There we, again, should we say unreasonably detrimental to the health, safety? Or should we say or that it shall be compatible with the health, safety, peace, comfort?
I think actually the way this is worded is better. We should steal this and move it. Because it says constitute a nuisance, which means there is a definition already of what rises to the level of nuisance, right? So I think we should steal this.
I was looking at whether we should put anything before detrimental, but I think from our discussion this morning, we don't. And then the conditions of approval, it's the same as we did with the AUP as far as the
Conditions of approval should also be mitigating any potentially significant impacts.
I'm sorry, I'm turning up my
Yes.
hearing aids.
We should probably just add that.
Yeah.
What was that, Julie? I'm
Just
sorry.
add that. Underneath this list of the different types
Yeah.
of regulation, they-
Yeah,
that says mitigate any potentially significant impacts identified through environmental review in compliance with CEQA.
should that be a part of that list?
Yeah.
Yeah.
Okay. And I would think that we want to have maybe as a new D, insert regulation of noise. We've got regulation of lighting. we've got
We have
regu-
a noise ordinance, so.
Yeah, but we also have
still-
lighting and signage
Right.
provisions and temporary use permits. Noise is often a major consideration.
Yeah, and this is where I kind of got off on what the difference between a temporary use permit and a special event permit, a one-time or,
As I understand,
And-
special is a part of, is a type of temporary.
right, but we haven't really addressed the special event section yet. It's gonna have a whole new piece, right?
But we have.
No, we're not,
earlier covered special events.
Not
But
in
not
here,
the
but I
news.
think aren't we gonna be doing something with special event permits?
I think we're doing this a separate standalone for
That was-
now.
That was my
you
understanding.
mean through the new provisions? What do
No,
you
that,
mean?
I mean,
Yeah, just the planning department is going to have a different special event permit ordinance or
Oh, well,
permit
no, that's
process?
something that after adoption of this,
We're gonna have the big
We're
other
sup-
discussion.
we're supposed to be discussing, or our intent is to further the discussion specifically on special events and then address any changes in a separate ordinance subsequent
but-
to the adoption of this
But
code.
will a special event be, so what is a temporary use? Like something like a farm stand or?
Yeah, so we call out the different types of temporary uses, those that don't require other permits such as a road closure permit or any other,
Right.
any other permit that would require, usually they're one-day events that, might be isolated to one parcel. So there are some criteria, I think Martha's trying to find it right now.
Yeah.
But we do have some criteria that differentiates between
I
temporary,
have it.
Yeah.
Limited duration.
And then we
not
do have
permanently
specific-
Alter the character or physical facilities
Yeah.
of the site where they occur.
right. So that is a determination that we need to make in-house as to where whatever it is that's proposed falls under either a TUP or an AUP or in fact a conditional use permit. And there are other applications in our code that specifically require a TUP. So that it goes beyond special
Like
events.
large
Yeah.
events, right?
so special event
Well-
could be any of the three.
Just to back up a little bit, so what a temporary use permit would be for, there is some category of your special events, but it's for mobile home sales offices, it's for filming, it's for mobile vending, it's for temporary outdoor sales, and it's for seasonal sales. And you need, in order to be able to do a temporary use permit, you need to meet all of these criteria. For say I'm doing seasonal sales. If you don't, or you want to do some other type of temporary use permit that doesn't meet any of these criteria, then you're at least doing an administrative use permit.
Right.
So the temporary use permit is really only for these specific
Right.
uses.
That could be like a Christmas tree lot.
Yep, yep.
But
We don't list
so
those.
it seems like there's significant overlap between this and a small special event. So you'll determine which it is, but so why that came up is we don't have anything that talks about, routing it to other departments. Would that happen with a temporary use permit?
No.
No. So you just said that it doesn't require any additional permits. So if it needs something from environmental health, like for a food vendor, or if it's going to require
Yeah, if it requires, if it requires some sort of discretion, some other permitting process, some other department that needs to be involved, whether it's Caltrans, Public Works, EMA, the building department, then, that might be the criteria that kicks it into an administrative use permit rather than a TUP.
Or a special event, depending on the.
Well, am I correct from what you said earlier, that a special event, depending on its characteristics and impacts, can be a subject of a temporary use permit or an AUP or maybe even
Or a
CUP?
CUP.
Right.
It's just that
Right.
special event there isn't a special event permit It's
No.
just that there are factors that have it fall into one of those categories.
So
Right,
if it
right.
has food vendors or requires sanitary facilities, or they're gonna sell alcohol, it would not be in this section. That's what I'm trying to determine,
Oh, okay.
or whether we should address all of those other things in here.
Yeah, see, and what I'm kind of referring to is current code versus what, so we've included uses that didn't include before, like the temporary mobile food units. So, yeah, I mean, so it looks like we're calling those out specifically as temporary. As far as the special events, I think that would have to be just on a, a determination.
Right, but so if you're doing something and you think you're a temporary use
Right.
permit, are you automatically not a temporary use permit if you require any of these other things?
If you're, a special event that requires, say, a road closure, then you're automatically
a special.
well, it's a special event, but that would be automatically an AUP versus a TUP.
So should we have, I don't think we have it here now, that a statement that temporary use permit can only apply where the requirements of the AUP and the CUP do not apply.
Right, so I just don't see any conditions referencing sanitary facilities, the needing a permit from environmental health for food service or temporary food service, or anything about needing a liquor license if you have alcohol sales, about sound levels.
Well, if any of those, it would then flop over to AUP or CUP.
Well, it doesn't sound like it from that
That's what she's saying, it
description.
doesn't currently state that.
No, I know.
That's why I was
That's-
kind of
no.
confused about where that line.
No, but I agree, it should be clear. But if
Well, I guess, and maybe I need clarification from Gina, like, I wouldn't say that just because you need an electrical permit, some other fire review or something, you would be bumped into an AUP. Mobile home sales, you're not going to have you're not going to have alcohol sales, but you may have something that maybe you
Like a
need to
building
get
permit.
a building permit. Just like filming, you might need to get some clearance from Caltrans or an encroachment permit for some part of it. Mobile vending, you obviously need something from health. That a temporary use permit doesn't negate the need to get any other kind of applicable permits. But just because you do need some other type of permit doesn't necessarily mean that you have to get an AUP then.
it seems to me we can cover that within, the requirements for an AUP and the requirements for a CUP, and that just all we need in here is a statement that if you have the requirements for an AUP or a CUP, the administrative use permit is not available.
I don't think that's what she's saying. I think she's saying that just because you
That's what
do
I'm
need,
saying.
well, then
So we're calling out as certain things needing a TUP, but in respect to special events, they could be either a TUP or an AUP or a CUP, and the discretion is left up to us based on the criteria that's outlined in the special events section as to which permit you
But
need.
if I understand what Martha is saying is that you can have a temporary use permit sometimes when there is another permit needed.
For some of these other, for some of the other uses,
So why can't
sure.
we just refer to what the requirements are for the AUP and the CUP and say, if you meet those, you can't, or if you're required to have an AUP or CUP, you can't have a temporary use permit.
I don't
don't know why.
I don't think it'll be that clear. I would think that maybe we just need something here that says there may be other conditions such as, meeting the sound.
What did we say? We have temporary uses in 1712-200.
Mm-hmm.
So let's go see
So that's what Martha has them up on the screen.
Oh, I can't read
Yeah.
the screen because I don't have my glasses.
You want to borrow mine?
I'll stay away from yours.
I think what complicates it is the special, you guys have this special event issue
Yeah.
thing. So I want to kind of park that because you need to resolve that subsequent to this. So if we just think of temporary uses are tied to the temporary use permit. So there's certain types of temporary uses that don't require any kind of use permit. And those are detailed.
Yeah, and then when we do the special event chapter, it'll probably be like the way we interpret our existing, which is we'll define special event in some coherent way and say, and even if we didn't define it, the more specific, if it's clear that the type of temporary use you have could fit into special events, and that's more specific to that type of temporary use, the law would say the more specific would apply, right? So.
Yeah, when
Then
you do
this
your
needs to-
special events,
the
I would
requirements.
separate temporary uses and special events. And temporary uses and temporary use permits and special events and do a special event permit. Like, just separate the conversations.
So perhaps we just need to look through the temporary uses and include conditions that if you were going to implement one of those, other conditions that might make
May
sense
apply.
here, or other permits, yeah, that's all. I knew I was a little lost here.
I am a little lost. So what you're saying is it's actually put down the requirements of what requires a temporary use permit.
Well, they have a list, but, or they have temporary uses listed, but they just don't have all the conditions that might be
But-
applicable to those uses
I thought-
listed here.
I
You
tried
mean
to,
beyond just the general
where do we find,
ingress, egress, traffic circulation, A through E?
Sanitary facilities, food service permits.
Okay.
Liquor licenses, compliance with the
Those-
sound and
Sorry.
our light that doesn't go off. So a Christmas tree farm or Christmas tree sales, I think that was one of those items. Like they might
So
have
those
lights up
necessarily-
that could bother the neighbors.
So maybe those aren't necessarily conditions, but are more of additional permits that may be needed.
Wow.
I think Martha had on the
Both.
screen
Well,
the list of temporary uses, and I thought it was 17.12, but that's zoning amendment, so,
It,
yep, 17.12.200 is not listed in my
I have it here
index.
somewhere.
Right, that, because it was it's in the uses that we looked at. So that was a previous one. So what I think could be an approach is that we need to state here, or in temporary uses, something to the effect that other permits and regulations from other departments and agencies may apply. But specifically for like the planning department looking at this, the planning department's gonna look at a request for a temporary use permit, and they may say, hey, yeah, your Christmas tree farm, I know that, it meets all the other criteria, but that light, because of where you're located, shift this. So this is where like the planning department may add additional conditions. You don't need to, the planning department's not gonna add a condition to get health department review or fire review. That they're just required to do that. This is just where like planning might.
But you're talking about other things that are similar to that, like regulation of fire protection, regulation of ingress and egress. Those are all other departments. Well,
So
here's the
what
lighting and
is
signage.
missing then from this list, I guess, I would say for you? What is it that you want us to add that you may need other things from other departments?
mostly environmental health for sanitation and food service things. So if you're having a fundraiser, if you're doing some kind of a farm stand that has food on it, you need to have some kind of sanitary facilities, and you're going to need a food service permit. So those are the two main things. You know, the other things are, planning does review whether or not you need a liquor license. Planning actually signs off on that. So those are all things. And then really, it does have a reference here already to lighting and signage, hours of operation, all of that. And it has trash debris. So that's part of. Well, I just think the things that are most commonly, you might have a condition from planning saying you need to do it, or that they would refer you to another department, should be listed here. So if we already list them something as a temporary use, so it's something somebody's thinking, oh yeah, mobile vending, you know? So is there something else that would be associated with that?
Mobile vending.
That's what,
There's some set standards we already have for mobile vending back in.
I'm looking at them.
Yeah. But.
I guess I would just say, there isn't an issue with saying you may be required, you know, other things may apply. But I guess I disagree that they would go under this conditions of approval, because these are things, ingress, egress, fire access, removing the trash and debris. Well, I guess the first two. Those are something you might look at on a site plan. The lighting and the signage, you could look at that on the plan. The removal of everything at the end, that is something that the planning might check. While planning does sign off on ABC licenses, they don't really require ABC licenses.
What we do have is kind of a advisory section of our application instructions that basically say, you know, for a successful event, you may consider whether or not you need X, Y, and Z, which includes some of the things that we've just said, like an ABC license if you're going to serve alcohol. So we kind of give that information in the instructions for the application. So, you know, as an FYI to people in case they hadn't thought about certain things, you know, we recommend that they go talk to the sheriff's department or, you know, the highway patrol if they happen to need, you know, some sort of, you know, security or whatever.
It asks if you've made arrangements for those
Right,
things.
right. So we bring things to the applicant's attention that there may be additional, you know, permits that you might need or consider. So we do kind of enumerate that as a kind of an FYI.
So I kind of appreciate Martha saying, well, these are things primarily that you could look at on a site plan, but I don't think that negates the fact that whether you're going to have food vendors and sanitary facilities, those would also be located on a site plan when you submit something. So I think
I mean, it's
need a heads
ultimately
up
up to
of
you.
what-
If you're comfortable putting it under something that the director is going to impose a condition, that's fine.
Well, it's not, they're going to get those, tell them that they need to get a sign off from environmental health or public works or whoever it is, but I think either we have to enumerate all the requirements in each of these sections in the description of temporary uses,
or we have to give them a heads up that they're just possibilities more generically in this section.
Okay.
We have to be careful, though, that we don't
Yes.
impose a requirement on the planning department that if they don't do it, why everything's out the window, or, that the permit should be permitted or something of that sort. I mean, I think it's great that the planning department points people in the other direction. It's another thing to require the planning department to do so.
Well, your special event permits requires you to go do that, so
Okay?
I mean, we just need to be consistent about what we
Yeah.
think, that's all.
One thing that I'm really clear on is that under purpose, we should have a reference to 17.12.200. Temporary uses are described in,
Yes,
because it took me a while. I found it impossible using the table of contents, but luckily my partner here pointed me in the right direction.
17.
I don't mean to throw the previous discussion off base. I do think then when we get to the conditions of approval, it's the same as with the AUP, that we put those, after the first sentence, we have the colon and the list of the things we want them to consider, and then get to the sentence about the director. Yes.
Yeah.
That would be part of the global change.
Yeah,
Want to beat it to death, I mean, that was really all, it just felt like we were missing references to things they might potentially be required to do.
and I guess my point, and again, I'm just gonna say this and I'll leave it, is that I'm not saying that there shouldn't be a reference that there may be other things they need to do. In my mind, it just isn't a condition that the director would add.
I'm fine with that,
Yeah.
but then I think we better take a look at the,
Then,
just make it consistent, whichever list things end up in. Some of these things are not necessarily things that director would add, so, or maybe they would,
then I think it was Julie's suggestion that we, the first sentence in 050 was ended with including but not limited to the items below. Which could be a part of the global.
Like removal of trash and debris seems like one item. Temporary structures and electrical service do require building permits.
Yes.
So it should be a different line item. Or maybe it belongs in that other list of other things you might potentially require from other departments.
Yeah, I guess that was just generally you have to clean up the site.
Yeah.
But, yeah.
Anyway, I think we've said enough probably, unless somebody else has something they want to ask. Julie, you don't have anything to say.
Did people, do people agree that we should have a reference to noise in that list?
Right. I think if we have lighting, we can have noise because we actually have a noise ordinance. We can just put it in the list too. And it's another thing that's on our applications. Will you have amplified sound?
Yeah.
And what hours will you have it? So it's already kind of,
Right. So are we on to waivers?
oh, good.
Oh, boy.
Let's throw them out. I just don't see how, well, you look at the first line here, purpose of this chapter is to establish a means of granting relief from locational, developmental, and operational standards, where doing so would be consistent with this title. It seems to me that that's inconsistent. That, how do you grant relief from a standard and still have it consistent with the title?
Well, here's an example. Say your fence height is limited to 3 feet, say. Somebody builds their fence and it's 3 feet, 2 inches. If you don't have a process or some allowance for relief, they either have to take it out or it requires a variance, which has very stringent findings that you wouldn't be able to make. Say someone is maybe doing a parking lot and you're like, oh, they're required to, well, maybe that's not a good example. Maybe they built their sign and they had it installed and the person who built it did it all and it's, again, 6 inches over height.
Yeah, I see the desirability of the waivers section for very, very minor deviances, either of something already built or if, I don't know what the reason would be, and unless you're modifying an existing building and it's almost impossible to make that change. I have a bigger problem just with the philosophy that we're talking about. We're conflating housing accessibility and physical accessibility standards, and I don't really see how they go together and how you would provide a waiver for those things. I don't, because that's talking about a waiver to provide an individual physical access to a facility, and those standards fall in the building department's realm.
Usually it's for public.
It's places of public accessibility. But I see the fair housing standards, there are some things, but I don't quite see, maybe I could come up with a story that would fit into this, but it just doesn't
legally,
work for me.
It does. I mean, if you're talking about things that are preempted by federal or state law, you're not waiving, you're submitting to federal or state law.
No,
Well,
I'm saying,
before we get too far in that conversation, so number one, just to back up, you do have to have these reasonable accommodation provisions in your code. We can separate them into a separate section, but they're also for things like, what if somebody buys a house and they need to put a handicap ramp in the setback? You know, that would be, they could do that as a request for reasonable accommodation. So
the concern that I have that doesn't,
It doesn't, with the legal requirements for variance, you're saying, we just need something to do that takes us away from those harmful ways. And we're calling it, as opposed to making them different decisions based on a certain amount of common sense or discretion. And I'm concerned.
Yeah.
and
I
actually,
agree.
Martha's example was the one example I could come up with that that there could be the need to keep somebody in their home, to make a modification to their home that required them to be in the setback. That's the one scenario I came up with. But you still wouldn't allow them to do it in their side setback because of the fire clearance issues. So maybe in their front setback, that would be okay. I think in most cases, you would just allow them to do it. It wouldn't, those are, a lot of times those ramps are fairly temporary in nature anyway.
they could be removed at some future time. But regardless, I'm not sure. I think the way this is written, I'm not very comfortable with the waivers because I can't see a clear way to separate things.
I had is, I don't, maybe Martin, no, I don't think the so there could be that this will be major and a distinction could be the level of review with the same finding.
Right, and could we make them? We'd have to look at that in the variance section to see how we would break it out.
Yeah, currently it's broken out by as-built versus proposed new construction, so.
But we don't want to encourage people regionally, oh, I'm gonna build my thing 2 inches over the standard.
Yeah.
Well,
Yeah.
and that's the difficult part is making those findings for those as-built. You pretty much never can make those findings because the majority of them could have been built without,
The problem.
without the problem.
Right.
I mean, usually they pertain to, either height or setbacks.
If they were built, and they're not right? If they built it outside of the standards, we still choose whether we want to enforce. The difference here is us listening
In advance.
Yeah.
Or we've adopted zoning standards that are supposed to apply. And we're saying, but it's okay to watch.
Yeah.
A little.
But I mean, that doesn't make sense to have the standard.
Yeah, but then.
And the
if that's right,
reality of it
like-
is, nobody
that's a
goes
little-
out and measures that closely anyway to say. So the other scenario I came up with was somehow something got built a little bit over, and when they go to stripe their parking lot, they notice that their parking spaces can't be 18 feet long. They have to be 17 foot 10. And so would we waive that? Yeah, we would choose not to enforce that. It's close enough. It's going to be okay. We're like,
And we can talk about some of those Jubilee,
or you discover a problem during construction that there was a mistake made. I mean, that does happen. People's layout skills are mixed. So,
Or
Yeah.
you just don't enforce, I mean, how many people are going to?
yeah, but to
Well,
tell
that's-
somebody, yeah, it's okay to design it that way.
Yeah.
But, and Julie, you just raised a good issue, is that when a neighbor objects, can you just say, oh, yeah, but we're not gonna enforce it? I mean, it's.
You don't have to say, thank you, we register your objection, thank you, we'll keep, we note
We'll
it.
look into it.
Duly noted.
Duly noted. Okay,
I think it is the asking in advance, that hopefully people can realize that if they have something that small, they don't actually seek to have it blessed through a variance process that doesn't allow for those type of findings. And if we do allow for these, I would never just say, this is in circumstances where we can't meet the findings. I wouldn't say that. If you wanted to include, some counties do have waiver processes, whether there's a potential difference between the political feasibility, political desirability of those and the legal defensibility of them. But, I mean, I would never call out that that's what we're doing.
I think that's the I mean, the whole idea of a waiver, official waiver makes me uncomfortable. But if you have somebody, okay, ask in advance, I only have this much room, and my parking spaces are gonna be 2 inches shorter than what you say, it's not a matter of deciding not to enforce. You actually have to either give your blessing or not give your blessing.
And, or you can
No,
find
they
a
could
way of.
redesign it to make their spaces the right size.
Well,
It's
yeah.
going to happen when somebody has made a mistake and they discover that they're a little short because the building got built a few inches over from where they.
Are you saying that that might be a reasonable purpose for a waiver?
Or the,
I mean, can
or
we-
the alternative that Julie mentioned of having a variance that is actually handled in-house with a checklist by the director.
I mean, he'd have, you still have to make
You'd have to make the
findings, but
findings.
it's not in a big, open, public.
So it's basically the relationship of an AUP to a CUP. This would be
Yeah.
the small variance.
Well,
Yeah.
or
And
minor.
what I would do.
I think that's kind of what this really is.
But it's how you say it too. I mean,
Except the
I,
finding.
with this actually just says we can make exceptions to the zoning code. The way it's written, it just says we can make exceptions,
Right.
which goes against how the zoning law.
No, sorry, just to clarify, it says dimensional requirements of property development standards not to exceed 20% of the requirement.
Right.
Which is a lot.
You could make it 10%, but I want to make clear the difficulty with the variance isn't who the hearing body is that you have to make a specific finding that there are exceptional or extraordinary circumstances or conditions applicable to the property that do not apply generally to property in the vicinity, that, they couldn't use the property accordingly unless you grant them that variance.
And there's a lot of
That's what
situations
Gina's
that
saying
just
is
don't.
difficult to make, that finding.
Yes.
So you can't just say, oh, they built it. You have to say, oh, well, there's a rock in the middle of the property, which prevented them from putting the building there, so they had to build it in the setback.
I mean, we could say something, what I would do is just not call it waivers, call them variances, and then just say the planning director has, discretion to.
Well, I think that's gonna be super confusing though, because then it's, how are you gonna distinguish the difference between the two variances if you're
Well-
calling them both the same?
We've had already considered
have
this morning,
examples.
minor revisions and major revisions. And
But-
it's really.
I mean, it's
same
just,
thing.
it's just a different
waiver,
word.
Just to my legal perspective, there's no authority for us to give waivers, because it necessarily is a variance from the zoning requirement, tiny as it may be. And I just, I would be a lot more comfortable if we had minor variances or whatever category we want to put them in, and maybe have different standards for the review than to call them waivers. I mean,
Would you be more comfortable calling this a minor modification?
well, it's a minor.
Just so
We have
hear you
zoning
saying,
requirements. We have zoning requirements. This does not meet the requirements of the zoning. And the remedy for that is a variance. So maybe I'm being terribly simplistic.
well, I'm just pointing out that, as Julie says, terms of art, a variance is a term of art and is specifically regulated by this. There's state in the planning and zoning laws have specific findings that need to be made for a variance.
I'm being convinced by, by Martha as she's saying. it.
Yeah,
I do agree with
that was a good argument.
Yeah, but if you're going to do it at all, which is a policy decision, I think you could say, make it very specific, like minor, have a separate chapter even that just says minor dimensional discrepancies or something like that, and have it very limited and have it based on discretion. I mean, again, it's how comfortable with, what's your comfort with the risk
Yeah,
risk levels? It's
but I think
really-
you've hit it, Martha, in that I see if you call these variances, why you fall into the state requirements. And it is waiver is what I'm getting hung up on. I mean, we waiving the law is really what,
I agree that the waiver is also not a great
yeah.
term.
But
I'm assuming, Martha, is this a term that's used widely in other jurisdictions?
Some call it waivers, some call it modifications. I would say are probably the two most common that I see.
Could we refer to them as modification to standards, development standards?
I wouldn't,
that's a
it
problem.
makes it worse, I think.
Okay,
I mean, it's up to, and again, I guess you have to make a policy decision about whether it's better to keep it clean and not have it, and just assume that it'll not be enforced, like nobody's gonna say, oh, shoot, I just discovered it's an inch off, or, or there might be circumstances where we can get, I can assist the planning director in developing some findings, which can be appealed within a certain time frame.
But what are you gonna call
Well, I'm just saying, or we could do, attempt to make variance findings that are unique to the property. So, it's up to you guys. It's a policy call. And it's an area where the desirability for it, state law don't necessarily.
so we still have findings that we have to make. It's not like it's just,
it? Maybe we should go through variances and then come back to waivers so that we're fresh in our mind just what the requirements for variances are. I mean, I'm being convinced by Martha that by calling these, recognizing that these are indeed variances, we're going to apparently fall into heavier requirements for resolution of those instances than we would want to have.
I think we just
Yeah,
have
and
to be really
I think like
clear.
Julie said, kind of the first question is, do you even want some ability to modify or waive dimensional standards like we have? If the answer is no, then this is pretty easy, right? We just get rid of the waivers. If the answer is yes, then we determine what we call them and if we have the appropriate findings and so on.
I think it is desirable to have something, whether it's, and a waiver seems clear to me, what we're talking about. I just feel like it has to be really clearly defined what kinds of things would be eligible for it and under what conditions.
Yeah, and it seems to me that it's going to be an as-built situation.
Wait a second, I have a thought. What about putting that in the actual zoning requirement, that instead of doing it as waivers, why don't we just make the standards for the actual, the development standards, so that within 10% or 5%, the director has discretion?
I don't think you want to do
No.
that, because you're going to have everybody say,
Right.
oh, I can just
I'd like
change
this
this.
has really got to
And
be
have-
that exception.
Yeah, I think it's going to be the oops factor needs to be a part of it.
Yeah.
That, gee, we thought we
Do
could
we
do
want to
this.
apply it simply to as-built?
Well, that's what I would tend to do.
But then you've got the scenario of the rock in the middle of the property that pushes your,
But didn't you know that?
Exactly.
That's a variance.
That would be, you could make the findings if there was
Then
something
you-
weird
yes.
about the property.
right, but I was just saying, do we want to make it as-built versus,
I think for the waivers, we
But-
do. I don't think having the pre-approval or pre-construction waiver makes sense.
I do think there are some conditions under which it might make sense to allow a waiver for very limited encroachment into the front setback for accessibility purposes. I don't think most of the time that is not going to be something that would even fall under the federal or state guidelines, because it's most likely going to occur on a private residence, which doesn't have any of those requirements. So, but it would make sense to allow somebody some limited encroachment in order to get into their own home and be able to continue to live in their own home. I think there are cases like that, and if somebody, most of those people are never gonna come to get a building permit to do that, or need any kind of clearance from, or they're not gonna request a clearance from planning anyway, but if somebody
So the
is
neighbor.
aware and does it, we don't wanna ding them for trying to do the right thing. So I think we could identify a few cases in which that would be allowed. You wouldn't allow it on new construction because they can just build it within the setbacks, design it so that it's gonna be as an addition to an existing building.
I do want to give some context to the accommodation for disabilities and the fair housing and the reasonable accommodation. So that is not available in the case of new buildings and rebuilds. We can pull reasonable accommodation out as a separate section, but I would really recommend against taking it out altogether, because really the state is specifically looking for these ordinances. And if it's not currently mentioned in your housing element as either needing it or needing to revise it, if you take it out, that I guarantee that will be the next comment when you go through the housing element. So everybody has reasonable accommodation. Sometimes they do it as a separate chapter. I find it cleaner to put it in with the waivers, but I would recommend taking it out. I would recommend
keeping it in. I just think we need guardrails on what it applies to. And I don't think someone can use reasonable accommodation to build something new and
They
say,
can't, but that's already in here. But what we have in for reasonable accommodation, I would really recommend against putting more things on it, because the state is gonna come in and tell you you can't.
I do actually
need to look
think,
into
well,
it.
there's different, part of it is state, the people doing state laws, the people who look at the variance laws are not involved in housing. And so it's like, it's sort of split up. I do think a court would be way more sympathetic to this type of a situation in the context of residential building than it would be commercially too.
and to retrofitting something to make it. So let's say there's an old apartment building and there is no way for them to make it accessible without encroaching, then that's an argument. So that we want to make this available to people. We're going to do the interior retrofits to make it accessible, but we need room to get a ramp in here. So those kinds of things I think make perfect sense. I'm not saying we don't want to make accommodations for accessibility.
But we could say something like measurement errors at time of construction.
But this wouldn't be a measurement error. It's you're retrofitting the building. The building is where it is. You only have so many ways you can. Or you need
limited.
to add an elevator, and that elevator shaft, there's nowhere interior to the building to structurally do it. So you're gonna build a new tower for that elevator for the 3 stories, and it's going to minimally impact a setback. Then I think those are all reasonable things and are the kinds of things we would want to do. Because increasing housing, increasing accessibility are good things.
And I think it'd be a lot cleaner if we did the reasonable accommodation sort of considerations in a separate unit.
I agree.
It just doesn't seem to mix here.
I think it.
I mean, you've educated me that there are reasonable accommodations that we should consider that we aren't required to consider. I mean, the private home situation. And so, okay, so we need to have, But to mix that in with, oops, I just built the house 6 inches too long, just seems to be in a different
I think
category.
you could have minor dimensional waivers for as-built conditions, they discover them, which is what you'd like
Right.
to use. But I also think you could have waivers that could be completely reviewed by the planning director, that with the intention of providing increased housing and accessibility that apply to renovations and alterations to make things more accessible or increase available housing.
But I think that's a lot easier to accept, to have, in having those as a separate
What would they be?
group.
They'd still
Reasonable
be a
accommodations.
waiver,
They would be exceptions for reasonable accommodation.
but they'd still be a waiver.
Oh, I understand, but mixing that with building the building 6 inches too
But
large.
but you could still have both of them under the waiver
You
category, is all I'm
could,
saying.
you could.
If what our intent is to have something that doesn't require a public hearing, that we have specific rules and findings for, we could have several conditions under which the planning director, he's not here to accept this responsibility, but I think it makes sense under those, and it's a way to acknowledge the need to increase our housing and the need to make our housing stock and even our commercial facilities accessible. When we have existing things that could be modified if we're just a little flexible.
I just think that it's, if you're presenting it to a court, I think if you're going, this section or this chapter has to do with reasonable accommodations, I think it's just something that people can look at with a lot more favorable consideration
Look, yeah, I
than the
mean,
mistake.
you look like a jerk if you're trying to keep somebody from building a
Well, yeah.
wheelchair ramp. I mean, yeah.
Yeah, okay, yeah, he's saying separate it out and put it in a
Right, no,
different section.
Agree with that, but
That doesn't-
I agree, but I think it could still fall under the waiver category, that's all I'm
Yeah,
saying.
it's-
Where
Yeah.
else would we put it? We
If it's
don't
a-
need a whole new
If you have
chapter.
two subcategories,
Exactly, that's what I'm suggesting.
yeah,
And both of those are going to apply to existing, either an existing building being altered, or existing whatever, being altered, or an oops.
And then how much, what percentage of dimensional?
I don't think you can say a percent, because it's, a lot of times that's going to give people, if you only have a 5-foot setback and you say you can be 10% into it,
yeah.
but the building code doesn't allow you to be any percent into it because of fire considerations, you're giving people mixed messages, so I think it's going to matter about the particular situation.
But I mean, I
So-
think that you're not having, I don't know that you want to say we can always give relief from dimensional.
Oh, I don't think we would say we can always give it.
But
But I think,
20%.
are you saying that under the relief of dimensional requirements, that should only apply to existing buildings?
Yeah,
Is that what you're
I
saying?
don't think we should suggest that people can design
Okay.
their new,
right,
so I think it's going to be, they made a slight error, that. And we're not gonna say, oh, guess what, you can't, now you don't have a parking lot.
well, I mean, might end up with,
20% of that's.
no, that isn't.
Yeah, but I think to Julie's point, a lot of that has taken care of by simply just on the spot saying, oh, that'll still work, or it's okay, we're not gonna
Well, and that still is, I like that particular flexibility, because currently what's happening is, we're finding ourselves in a very awkward situations, where usually it's brought forward to us upon transfer of title. So, an older home goes up for sale, somebody else wants to buy it, and they realize, oh, the house is 3 feet into the setback. What do we do now? Well, you look back on the building permits, and they got a permit, and it was reviewed, and there were numerous inspections, and then there was a sign off, and there's a a C of O on the property. So
But there would be.
at that point, it's like, well, we've obviously already
We
granted.
can't make them take it down.
No, you
Exactly.
can't, but you can't make those findings
But you
in the
don't-
variance either. So I'm saying that a waiver in that particular
You don't get a
situation.
waiver. In that situation, it's,
Well, that's not what our code says. Currently, our code requires any encroachment into a setback for an as-built structure to require a variance approval by the planning commission.
that's for asking in advance. If we discover
No.
something.
No,
No.
that's for an as-built.
As-built.
structure.
All as-built variances have to be approved by the planning commission under the same findings.
But I think in that, I guess what I'm trying to say is, in that situation, we would have other legal problems beyond needing a variance. I mean, there are other doctrines that could get in the way of our.
What happens when you don't approve it on an as?
Well, that's the thing, I mean, if you look at it realistically, you can't make those findings. So what our current practice is that we review the building permit, and if the building permit was permitted by, permit, and they received all the building inspections, and they've got occupancy permit, then we've basically said, we've, in a sense, approved your variance, and we're not going to make you apply for an as-built variance.
But that makes sense.
It
when
makes sense.
If we've made the mistake,
Yeah,
like,
right.
if we've made the mistake, I don't think the variance rule applies. There's other things that kick in at
Yes.
that point that
Right.
they give them a right to keep it. We don't have to worry about the
Governmental
issue of the
estoppel.
Right.
Okay, yeah.
Yeah.
But for even for those situations, for those
Yeah.
people that are looking for that hardcore, oh, I need an approval, a variance or a waiver approval could actually be beneficial. But I like kind of Michelle's idea of perhaps maybe just applying it to as-built situations, oh, our foundation is already poured, and we're now realizing that somebody misplaced it on the
Yes.
lot.
Well, that's what I said. Did you want to have how did you want to limit the dimensional requirement waivers for as-built? At what point? So let's say somebody just builds the thing. I mean, do you want to say for which a building permit has been granted, or how did you? I mean, what if?
Oh, you mean at what point?
So in other words,
What if they didn't get a building permit? What if it was something they needed a permit for and they didn't get one, and they just went out and built it, and then they got busted? And now everyone's sitting around going, oh gee, you're in the setback.
Yeah,
Now
but
you
they
got a
built
problem.
it. But that's what I'm saying. Do you want to say that they have to?
Yeah.
Already, do you want to limit this to as-built that have existing building permits?
Yeah.
Yeah.
Yeah, probably. And I would say, well, unless it was built pre-building permits,
Well,
you know?
that would be
That's
Without
Yeah,
a
exactly.
required building permit, yeah.
Yeah.
What if you use language, it's not available for new buildings, demos, rebuilds, or additions? Like what if,
Let me look.
Oh, okay, so you're saying use the same language under
Something like-
dimensional
yeah.
requirements? Mm-hmm.
How does demolitions fit into that sentence?
demo and rebuild?
You choose to demolish your home.
Yeah,
and rebuild it.
But I mean-
Or demolish a
Oh, I see.
portion.
So
Yeah.
what you're saying is demolitions and rebuilds are one unit then?
Right.
I was seeing new buildings, number 2, demolitions, number 3, rebuilds.
Oh,
So you could have demolitions /
slash
rebuild.
rebuild?
Yeah.
So the description of accommodation of disabilities is pretty good, actually.
Yes, it is, but it's still, I would love to see the reasonable accommodations provisions be separate from, separate within the same chapters.
Well, that's there, accommodations
No,
of
I know,
disabilities.
but it's
It's under-
all part of,
I'll just separate it, and I'm gonna separate it into its own chapter.
okay.
Reasonable accommodation, because that is something that's more particular than, yeah, I think I'll just be cleaner.
That would be great.
I'm not quite sure how to do the dimensional thing, but I think what we're looking for is acceptance of minor dimensional deviations. But you hate to say that we're gonna do that for you on an as-built basis, because I think it does encourage people to just say, I wanna move it over and look here, we can get a waiver for that.
Yeah. So,
But I do think, so, yeah,
I think you have to have something about good faith mistake.
right, yeah, exactly, that's a good.
I'm just looking at all the construction, we make good faith mistakes.
Well, no,
Yeah,
I think it's,
I'm that guy.
I think at this point, we probably have some good direction on where to start with revising these. I would, and we can look to start drafting it to kind of apply to the mistake kind of thing, but I would think about, is it easier if we're just gonna allow, say, up to 10, a small one and up to 10%? Is it easier just to say you can ask for an advance or you can ask for forgiveness, just to avoid if someone's gonna do it, you know they're gonna do it, and they're gonna, just like Julie said, like, oh, it was good faith. And just the process of calling them on good faith.
I guess I don't fully, maybe I'm missing something. What is wrong with just putting that flexibility up front in the standards themselves, as opposed to having to waive them? It sounds like.
Well, I mean, this is still up to our discretion. We don't have to approve
guess-
the request for a waiver.
But do you
right?
understand what I'm saying, Martha? Like, couldn't we just
Why
put
have
it?
a standard?
why not just make the standard
Right.
10% bigger?
Yeah, or smaller, whatever, dude. Yeah, I don't,
Philosophically, I agree with you fully, Julie, but in practicality, I'm not sure that.
and I think the
Yeah.
waiver at least requires them to have a reasoning for doing it, not
Right.
just to be able to go, oh, I know, it says there's a 20-foot setback, but really, I can take 10% off of that, so it's really an 18-foot setback.
You could say under unique circumstances or something along those lines.
I just think you would be saying that so many times, Julie.
Yeah.
You'd be, it's such a mess. And the point is to not be like, hey, you don't want to be saying like, hey, guess what? You can waive this. Hey, guess what? You can waive this.
Yeah.
And this is really like, I mean, not that it's like hidden, but it's just this like tool.
I just
For the
can't- I think
county to
lawyers
have.
have a lot of trouble. Like if I were a judge and stuff, I mean, I think lawyers approach this differently. I would want somebody to show me where there's room for this.
Well, that's what we're saying.
Yeah.
So for new
Yeah.
construction, it's hard to say why you would need a waiver unless you have some extraordinary condition on your site, and then you probably
be able to apply for a variance.
Yeah.
Maybe not, I mean, maybe that's what we need to be looking at is where is that? When we get to variances,
Maybe under extraordinary circumstances, relief from dimensional requirements not to exceed 10% shall be considered, or something along those lines.
may be considered by.
Maybe
Yeah.
considered, but under extraordinary circumstances, not, and not call it, I don't even like calling them waivers, but
No, I agree.
I almost would not even have the section called it.
Exception.
You have reasonable accommodations, and then you have, relief from extraordinary circumstances, and,
Well, do you just want to get rid of it altogether?
or there's a part of, I mean, I kind of would want to get rid of the whole thing altogether.
I do think we need a mechanism for planning to say, yeah, we can live with that. Look, you're already halfway there. Like, let's see what we can do. What can we have you do?
We could also say the
That
planning
would work.
department shall develop a policy for handling extraordinary requests.
Oh, I like that.
I just.
Take it, Gina.
I feel like that you have to have it be on a case-by-case basis, because otherwise, you're just saying, we have a way to let you have that extra.
Mhm.
And as soon as you put a percentage in there, it sounds.
I actually think it's
Exactly.
better to have it from just the defense, I mean, likelihood of challenge or
But
whatever.
more
to exceed.
Yeah, exactly.
Not to
On a
exceed,
case-by-case
not to
basis,
exceed 10% or
Yeah.
something.
Not to exceed
Yeah.
would be fine with me,
Yeah.
so that
If you
you're not
say not to
guaranteed
exceed-
that.
If you say not to exceed 10%, they'll come in, of course, and request 15% because of these exceptions that they have. But if you said 5%, then be willing to go to 10.
Well, but if we say, you've got to show exceptional circumstances to get
Yeah.
to the
You-
10%.
Absolutely.
The problem, it's a risk management issue, right? It's not easy to find where this fits into the zoning laws. And so the question is, how comfortable are you in the event of a challenge for the authority to do this? I mean, and if you set up to 50%, you're pretty well guaranteed that somebody's gonna challenge it.
But by
Yeah.
treating it as an exception, not a waiver, then it's an exception to our own zoning laws.
You could just say like exception for extraordinary
Yeah,
circumstances.
exactly. Now that I'm a lot more comfortable with than saying you have your zoning law, we have our zoning law, but we don't have to follow it. And
Right.
that's where I have the problem.
Right.
So if we say this is part of our zoning law, and the exceptions can be provided under,
We could maybe maybe we can put that language under the development standard
Exactly.
somewhere.
And it's from
think-
locational
Dimensional.
dimensional standards, not this operational standards and developmental, which seems, I know, trying to cover things that we haven't thought of.
yeah.
Yeah, putting it in a totally different section, like where the standards are, the
Yeah.
affirmative, here's what you're allowed to do, and having this,
I think you've got it.
yeah, I think you're right.
I think that's the way to do it, because it's part of our zoning law, not that we're saying
Right.
you don't have to follow the zoning law.
But you
So
still
what,
have to have a
sorry,
process for
where are you
doing
saying to
that.
put it?
Oh, yeah, no, I'm under exceptional.
Maybe under
circumstances.
countywide regs or something along those lines, or in the actual zoning standards.
Yeah.
But you still have to have a process, so you're still gonna
That's
have
why
a
we're-
waiver process, or even if you call it something
I,
else.
right,
Yeah.
but you can also put it someplace else and you can still say there's a process. right?
Yeah,
So you're saying, so the waiver section might only have,
We wouldn't call it waiver, we would
What
call
And
it,
exceptions.
never call it waiver.
it would have the same language that we were just talking about, but we would put it under our affirmative, the places where we say, here's what you're allowed to do.
Yeah, exactly.
It would be part of our substantive, there'll be this we'll have all the rules and then maybe under each zone, there will
Can
be
the exception.
that, an asterisk or something that
Yeah.
says, under extraordinary circumstances, relief for.
may request.
May request,
Well,
yeah.
No.
do we really want to advertise it?
Yeah.
Well, this
I mean-
is advertising it.
Well,
No.
not like that, though.
No, I just want to have it in every section, so every.
Oh, by the way, I have a unique circumstance. Is there any relief to this? And they're approaching you with the problem in hopes that you can collaborate and come up with a solution.
Yeah.
That's not everyone reading your list of setbacks going, oh, I can make a little exception here.
If I build it first, then I will.
Yeah.
So
Maybe we're not ready for this yet.
Yeah, I think, in conclusion, I do think that likely you should just do reasonable accommodations and variances and maybe at a later date, look at this waiver situation. A problem with Julie, your approach is that there's dimensional standards throughout your code. I'm looking at even the location of required parking, allowance for off-site parking. Required parking may be located in an off-site place provided it's within 500 feet along a pedestrian route.
No, I see what you're saying. I'm trying to, I know that non-conforming uses are defined differently. I'm just wondering if that, I think that what Commissioner Ladish and I are just saying is make it look like this is something,
It's our
that
standard.
this is the flexibility we're building into our standards in some way, shape, or form, as opposed to, here's where we're gonna allow an exception to our standards, which begs the question, why do we have standards at all?
Well, so what if instead of saying
So-
waiver, what if we called it flexibility or something like that, and then put that in?
I think
Said
relief
under
for
these
extraordinary.
under extraordinary circumstances or for reasonable accommodation, flexibility may be available.
Yeah.
No, I liked what you said, but I think we can't just say flexibility, maybe, but I would just
Well,
say,
exception.
I think you should, as you
Or
did before.
exceptions.
Yeah.
Exceptional release.
But I think that defining it the way you did was a better way to go, like, not to exceed, I think you do need to put it, draw a line around it,
Yeah, you have to have parameters.
so.
Right.
I mean, otherwise, how are you gonna, where's
Maybe
the
we-
line
maybe we
between a
can work on
variance and
this.
whatever this thing is?
Maybe we can work on it offline.
And
Okay.
I think if we say may be available under extraordinary
But I don't
extraordinary is
think-
probably not the word, but.
I mean, I would
Yeah.
just say, relief from dimensional requirements not to exceed 10%. I think we can say the language that you had before, and I think really it comes down to what we call it
Yeah.
and where we put it.
And philosophically,
It's the
I
type
agree.
of
Agree, and then it
location.
can be very short.
Yeah.
Not,
Right.
not really, we don't have to have as much.
Its own section.
I just don't think it should be right under variances.
Yeah.
Yeah.
No,
Yeah.
to me, it makes a big difference, and I appreciate your suggestion, Julie, that it's a part of our zoning law, not a waiver of our zoning law, which I don't think we're authorized to do.
Right, okay, so,
So what I'm hearing is that this gets termed exceptions. This is limited to 10% and something about extraordinary circumstances or exceptional circumstances. And it's only applicable to existing buildings.
no, I think then what we're saying is that it is available under extraordinary circumstances, like the example, so there's a humongous rock that can't be moved on your site. So you ended up having to move the building over. And you're trying to get permission for that in advance of doing it.
Sounds like you could get a
That's
variance
a
for that.
variance.
Yeah.
That's absolutely a variance.
Yeah.
I think if we take a little time and exercise a little creativity, we can figure out where else to put it.
Please do, but I see that.
And I think we could do the reasonable accommodations and this thing that we're talking about together,
Together.
but I wouldn't put them near variances.
Yeah.
Under
Okay.
variances.
Right.
Sorry, conclusion for my role in this, if that's the approach, I will hand it back to you, Julie, and the county to work out. That,
Okay.
so that's fine, but that approach,
Yeah, I think it could use. I knew this was gonna be our stumbling block section.
Again, we can just pull it out all together.
I like the idea that the county wants to be flexible in trying to help people solve their problem and
Yes.
that's specifically with existing buildings where we want to allow people to be able to continue to use them.
I think that if I like spent an hour by myself, I could
Good.
figure out.
Yeah.
I really do.
Great.
Because you've more than heard enough from us.
Now,
Well, I'm
So
just
you-
saying, like.
now
I
you
think
just have to
once
find
I
them
have
out.
the policy direction, I think I understand.
Especially one that you suggested, it's easier. Great. Because then we avoid the problems that we would have under the required findings where it can't result in a change in land use or density that would be inconsistent with the requirements of this title. I mean, that was we don't have to worry about that sort of thing. Because it will be in compliance with the requirements of this title.
Well, I think if you use the variance section as a starting place, you might be able to just massage it into an exception section.
I think, I'd say keep it separate from variances.
It is, that's what I'm
Okay.
saying, but use the wording, I'm reading the purpose and applicability here and saying that that might be.
Intended to provide a mechanism for review.
From strict
That's what I
application
highlighted.
where it
Yeah.
would deprive, instead of depriving the property owner of privileges, it might be where it would allow under certain
Let's,
conditions. to-
let's let Julie do her thing.
Right.
And, so now we're gonna consider variances.
Well, I think, those are kind of
Yeah, I mean,
set.
Yeah, I have some questions. I mean, I think that the purpose statement is
perfect.
good. Applicability, variances may be granted to vary or modify dimensional and performance standards. But then the second part, but may not be granted to allow uses or activities that this title does not authorize for a specific lot or site. But I mean, what about front setbacks? We have,
No, that's about
That's,
uses.
that's not, this is uses and activities, so I think that applicability thing was good, which I also thought could be used in our other
Okay.
exceptions. It's,
okay. Uses or activities, I see.
we're
Not
just trying to
dimensions.
be a little flexible on the exact dimensions.
Okay.
Without inviting abuse.
Right.
And did we need to have another provision about indemnity in here in the procedures?
I think we found that there was, we should
It's
put
a
a blanket
blanket.
indemnification that I just lost at some point. 'cause
Okay.
Too much time has passed.
Okay, and then again, let's see, required findings under 050.
Those are state.
Hmm?
The findings are state findings?
Those are state findings.
Yeah,
Yeah.
state law.
Yeah, under required findings, I just had the first paragraph, the end is say in which case it shall state the reasons for that determination in writing.
Well, that's a fine, you don't like.
No, it doesn't say in writing now. I'm adding in
Oh,
writing.
sorry. I read it and in my mind I put in writing showed up. Then plus it wasn't there.
So the state requires a finding that the granting of the application will not be detrimental.
Yes.
Yes.
And so putting in unreasonably or significantly
No.
or something.
I would not fix the
We
state
don't
law
want
in
to
that
change
sense.
that.
Okay, okay.
You can be stricter if you want to.
I
And
understand.
add more, but
Yeah.
I wouldn't.
I think they're strict enough.
Well, that's what I'm saying, like, I don't think.
Yeah.
It turns into a problem if we try to change.
Yeah,
the
I
language.
agree.
Now, in the conditions of approval, it's similar to what we had in earlier things where after the first sentence, that should end with a colon and list the conditions. And then
Yes,
Have a-
exactly. Put that second
Put second
sentence
sen-
down below.
down below, yeah.
Our go-tos.
Yeah.
And somehow here we have the sequel language. There's.
Yeah,
We could just add that same, that could be, that language is fine, I think.
Right.
We can just add that to the
so
other
we'll,
section.
yeah, we'll go through and
Yeah.
add that to all the others.
And we don't
sections.
need to here talk about how plans and drawings and such shall be deemed conditions.
I'm sorry, Tim, what was that?
We don't, earlier, we had a provision about how plans and drawings and, site plans and that sort of thing shall be deemed as conditions. Here we're talking about the authority may impose reasonable conditions. Do we need that sort of statement here?
Yeah, that's not a bad idea. So,
No, the previous statement that you're talking about was in the common procedures, so that's just
Oh, okay.
commonly have.
All right, great, thank you. Word your words, got it. Okay, I'd go into plan development.
The new and improved PD.
Well, once Moke Hill is out of the picture, my questions are not, is this, do you contemplate that you could establish a planned development overlay zone on an existing developed area? Or would this be only for new?
There are already.
Okay,
So there's a number of condominium plans, townhomes,
okay,
other subdivisions that were planned unit developments. They're usually identified on the map as such as a result of, the approval. So it's how they were presented, what was approved, what was agreed upon. And as I've just said, they're identified on the recorded document that in most cases is a map that identifies them as a true planned unit development. And so there are currently numerous parcels in the county that have a PD overlay zone that depicts that.
but
Approval.
the old design review, the PDs that we used to encounter all the time on the new zoning map, they're no longer PDs as far as,
So what I've done is we identified all of the PD overlay zoned parcels in the county. And then I had to go through and distinguish which ones were planned unit developments and which ones were design review.
yeah.
For McCollum Hill, everything that was previously zoned PD was already rezoned DR, so I didn't have to worry about them, although I did find a couple that were within the community plan area and otherwise depicted on the historic map in the, I think it was the Gateway area, but I did find a couple that we missed that I've proposed changes. But for all of those planned unit developments that currently exist, the PD overlay zone will remain. All of those that fall into that area of I'm in a community without design guidelines, and this is not a planned unit development, but the PD was truly applied for design review purposes, usually in conformance with the community plans at the time. All of those are just simply being removed, so it'll just reflect the base zone.
Great.
Yeah, and hopefully I got it right. I'm going back through the list for like the umpteenth time, and it's quite lengthy, but
Thank you. I mean, it's a common sense.
yeah.
result.
So hopefully that clears a lot of problems.
Then, okay, I would go to 060B as far as extensions.
Mm-hmm.
Uh,
Yeah.
So under one, I'm just not,
You said 060 what?
B,
B?
yeah.
Oh, well, I have a
Achieve the
question.
general
Oh, maybe it's
conditions of approval?
No, extension. Extension,
Page 40.
page 40.
Oh, sorry, 10, okay.
But you have something,
Oh, I flipped back to the wrong page.
okay.
I was,
Did you
sorry.
have something?
So I had an extensions question with respect to phase development. So they're probably related here.
My question was this number 2B2, such extension shall be approved for not more than 2 years. That sounds like the total of extensions. If we don't mean, if we mean that you can have 2-year extensions up to a maximum of 12 years or something, that's where we ought to say it. As I recall, why we have situations where we have had several 2-year extensions, but I thought there was some limitation on the total amount of extension time.
That's on subdivision.
Yeah, I don't,
know, But
I don't think we allow currently any extensions of use permits or other, in this case, a plan development. Anything other than a tentative map.
okay. So
I don't
then
think we allow anything other than a tentative map to exceed 2
Okay,
years.
then I would suggest we say such extension shall be approved for not more than a total of 2 years.
Not 3-year
So-
either,
Right.
I
total of
think
2 years.
So that's my question is, if you have a phased development, it could extend over many, many, many years. And so I don't know how that works with the 2-year extensions. And-
Somehow we need to clarify this. How's
Yeah,
that?
so I think, because you can have up to 1 year between phases, according to this. But that might not always make sense. Market conditions might require you to defer something longer than that. And then the total, say if there's 5 phases to the
Right.
project, you're gonna be out there
Right,
15 years in the future.
right. And are you
Plus,
okay with
how
that?
long well, it doesn't
I
really
mean, no, I know,
say
but we
here.
can make it say that.
Yeah,
Yeah,
yeah, so I'm not sure. I think I am okay with it extending a while, but I don't think it should extend indefinitely because
okay.
at some point, it might not be the right project, and
Yes.
depending on what the conditions are,
Correct.
times may have changed enough that it doesn't even make sense to allow it anymore.
So it would be 2-year intervals then, as opposed to 2 years.
I'm not sure, but the other thing is that just construction time, depending on where it's located, like something at a high elevation,
So do we
takes
want to
more
leave it up to
seasons.
our discretion, or do we want to have a hard fast
Maximum.
maximum?
Yeah.
I mean, do we want
It's
to,
gonna depend on the size of the development.
well, this is still,
This is, it's a discretionary thing. The
Right,
planning
it's
director may
discretionary.
approve. What we're dealing with now is a limitation as to what he may approve, so that it's what he can approve. So such extension shall be approved for not more than a total of such and such.
Do we want to be consistent with maps and say 6 years?
Sure.
Well,
I,
another option would be that you can do, the director may approve a two-year extension, and that could be for, if it's not phased development, that's just for the PD plan. If it is phased development, it could be for each phase.
yes, I think that makes sense.
Okay.
And then if it is discretionary, so if it is where, it is, say, 10 years in the future and things have changed, the director doesn't have to approve it.
Right, then the question is, do we want to also include total extensions not to exceed some number of years? How far out in the future do we want it?
Yeah, some of these projects we've got sitting around
Yeah,
for a long time.
Right.
I can name a couple that were alive or existing for over 20 years
Exactly,
from approval
and we would never.
to actual recordation.
So why don't we have it that you have, 2 years at a time, subject to the discretion of the planning director with no final limit on it?
I think we might want a total limit on it.
Okay.
That's because we see these subdivisions that Gina's talking about. We would never allow someone to design a subdivision in the way some of those are designed, and they are still building them out 20 years later.
So what happens in the interim though, let's say if you put a cap on the length, say you say 6 years, for example. And then of course, 9 years down the road, on 9th year, they decide then, because of conditions, proceed with the development. Do they take yet another permit, start over? How does that work?
Right,
If
so
we
what's
put
a
that-
reasonable number of
Yeah.
years for them to be?
But if,
I'm thinking about a couple places in Calaveras, for example. They started, they went through, I guess we'll call it phase 1. And then years later, more than 6 years later, I think maybe even more than 9 years later, they went ahead and then extended or continued with the other phases, even though they had already done some of the grading and that kind of stuff. So what happens in those cases? Do they resubmit?
can we let it, that's what I was suggesting, is we leave it to the discretion of the planning director. So when you do have changes that make the previous approval out of date, that he or she can use discretion to say, no extension. That's giving a lot of power.
Martha, can you give me an example of a planned development that's not in conjunction with the tentative map?
No, so the PD is typically done with it, but in theory, you could approve, the board could approve a PD without approving the map at the same time.
Oh,
They typically don't because they want to see it.
right.
But you could establish a PD zone. You could say hey, I own this property. I'm going to do a PD zone here. Get that in place before I do my map. Yeah. Just people don't, right?
Yeah, because I can't think of
That's
a situation where we've ever done that.
And it
I
doesn't
mean-
make sense because their PD could run out
Right.
before they could even get their map approved.
Well, it's likely to run out. I mean, because if you look at the extensions by subdivision map act, your map is going to extend well beyond
Well beyond this.
a PD approval.
Exactly.
even with an
And
extension.
What constitutes progress on this PD? Is it completion of construction, commencement of construction?
Well, and how do you, yeah.
It seems like commencement of construction is probably what's contemplated here.
It just seems like the two go hand in hand. I can't
Or pulling a
envision
permit.
approving a PD without a map.
Right.
It just doesn't make any sense.
You know, we could have subsection 1 in here without subsection 2. So that the extension shall be approved only when it is found that the circumstances under which the permits were granted have not substantially changed. I mean, that's really what we're talking about.
Yeah, that's actually pretty good.
No kidding.
Yeah. I mean, that's a great, for not more than 2 years and just, but we're not saying how many extensions
No.
they can apply for.
No, it's just that there has to be this finding that the circumstances have not substantially changed.
Maybe that takes care of it.
So we just need to restructure so that it isn't a number 1, it's just, instead of in accordance with the following, it just has such a, shall be approved only when it's found, et cetera.
It's, Martha, are these pretty usual PD timelines? They seem pretty tight to me.
Which timeline's awfully tight? The 2 years seems awfully tight.
It could take 2 years to build the first phase.
Oh, yeah, no, that's why I'm suggesting we take out the actual stated time limitation.
In which section? In the second?
No, under extension,
Yes.
we just have it, so the planning director may approve extension of times for PED plans, including those by the planning commission or board of supervisors, only when it, or if it is found that the circumstances under which the permits are granted have not substantially changed.
Oh, I think you probably still need something. I was looking at the very initial one.
Ah.
That says 2 years, doesn't it?
Where? Oh, up under expiration? Yeah. PD plan. Approved PD plan may specify a development staging program exceeding 2 years.
Oh, it does say may specify a development staging program exceeding 2 years.
Right.
So I think that's actually covered.
With it
Yeah, so
being-
that basically says you're setting that with the approval
Yeah, you're
of the permit, so you're gonna establish that right off the get-go.
right.
Depending on, and
You
then
have to
that gives
start
you the
with
flexibility
years.
depending on what the project is and how extensive you think it's gonna
Exactly.
be and how much time it's gonna take.
Look at, Martha thought of a lot of that already, and she's covered it. We just have to read more.
She's just waiting for the rest of us to catch up with her.
Yeah. We're catching up to you.
Let those little rats in the maze kind of scurry around.
Okay,
Uh,
let's look at those amendments.
I'd go down to B3, anything before that? My only question is when the terms exceeding the minimum is kind of strange. I'd say, and for 3, an increase or decrease in the floor area for any non-residential land use that results in the floor area being less than the minimum or more than the maximum stated in the PD plan.
Yeah, I see what you're saying.
Exceeding a minimum sounds like it's more than the minimum.
Right,
Yeah.
okay. All right, so your suggestion again was,
Okay, it results in the floor area being less than the minimum
okay,
or more than the maximum stated. Anything else in plan development?
Don't think so. Now, the joy of development agreements. Was there anything, Julie, that you?
No. You mean on development agreements?
Yeah. No, on PD,
No.
before we leave it.
I would go down to 020A. I think the purpose paragraph is good and it fully reflects what the state government code provides. Now, this is something I probably have missed or I've forgotten about. Under 020A, this procedure is available where a qualified applicant. Have we already stated somewhere what a qualified applicant is for development agreements? If not, I think we need to,
yeah, I thought we hashed that out earlier.
yeah, I don't know where,
I don't either,
okay?
but I remember the conversation.
If you don't mind putting a question
Okay.
mark there and
Yeah.
make sure that we've covered it.
Yeah, we discussed applicant with, under the common procedures for application.
Okay.
No,
Oh, okay.
good.
Then, but we can hyperlink that qualified applicant.
Yeah, again, that's the hyperlink question item that we have noted.
Then I go to 040B4, which I just don't understand. If the development agreement requires applicant financing of necessary public facilities, it may include terms relating to subsequent reimbursement over time for such financing. When we say applicant financing, we're talking about that the applicant's paying for it.
Mm-hmm.
Okay. Maybe there's a better word than financing, but then I think may include terms relating to subsequent reimbursement by the county, right? Isn't that what we're talking?
Sometimes it's by other properties within
Oh.
a area that,
Oh,
so they build a
Benefit
bridge
based.
or
Right, right.
yeah, do road improvements that are
Okay.
shared.
okay. So, and is that set forth in 65865? In the government code?
Maybe the applicant financing should be applicant funding.
Yes,
Oh,
that would be much better.
That sounds like they're
Right.
borrowing the
Right.
money. That's not our business.
Right. No, that's much better.
Unless the government code actually uses that term, which I have no idea.
I don't think the government code talks about that. It talks about it in terms of the funding. Look at the government code.
We can check it again. I'm sure Mr. Harnish will check it again.
Yeah, okay. And then let's see. Oh, then we get down to public notice and hearing. And recommendations to the Board of Supervisors. We have many different chapters that have similar provisions that we would I take it that on, and this might be a part of the requirement of the, well, let me start again. If the planning commission has approved something, usually it doesn't, if we're talking about a CUP or whatever, it doesn't need to be considered by the Board of Supervisors unless there's some sort of appeal by some interested party.
Correct.
Here, and in other,
I think the board has to actually.
the board has to.
Yeah.
Development
County-
agreement.
It's
It's a
entering into
county
a contract.
Right.
Yeah.
Yeah.
Okay. Then, then in subsection 3B, it's saying the Board of Supervisors is not required to take any further action if the Planning Commission is recommended against. It's not required to take any further action unless appeal is filed in accordance with. Now, I take it then we don't have to be more specific by saying is filed by an aggrieved party, an interested party, if that's all covered in our appeals chapter.
Where are you?
I'm on
Board of
page
Supervisors.
43. No, we're right above Board of Supervisors. If the planning, denial. Planning Commission is recommended against the development agreement. Board of Supervisors is not required to take, and I would strike out further, just take any action. Unless appeal is filed in accordance with section so-and-so
We have all
appeals.
those procedures already.
Yeah.
We have all those procedures already as far as who can file the appeal,
Right.
et cetera. Okay. Okay. Then, under B3, again on page 43, it seems strange that the matter can be referred back to the Planning Commission by the Board of Supervisors, but the Planning Commission need not hold a public hearing
That's,
on those matters.
Yeah.
that's in, there's actually state law about that.
But can't we make things more stringent by saying, yes, we will?
I mean, you can,
It just seems to
You
me,
can.
as a matter of public policy,
yeah, you could do that.
that, that if something's referred back to us by the Board of Supervisors, it's a
We can
matter of
have a
someone.
meeting. I mean, I guess the difference is, do we need to notice it as a public hearing?
Right.
Or do we just put it on the agenda?
Right. It doesn't mean that it's
I
not a
see.
public,
It will be publicly noticed as a part,
As a-
part of the.
On the
As
agenda.
a-
act, as part of the agenda.
right,
As opposed to actually holding a public
a
hearing.
public
which-
hearing.
When you hold a public hearing, you're also conferring rights on people that might not otherwise have them, et cetera. And this is just about, does the county want to enter into a development agreement? So I think it makes sense to not have to have another public hearing.
I would say we would want to only put in here what's required by the law.
Right.
Obviously, it's gonna
Yeah.
take place at a
Well-
public meeting, so.
And I don't think we want to change that, that requirement just for this and
Yeah, no, but how
not
about,
consider it for
how
other,
about just not having that
Yeah.
last sentence?
right, oh, no,
Be referred to the planning commission for report and recommendation. That way it'll get on the agenda and blah, blah, blah.
Just,
well, I think it's important though for us to acknowledge what requires a public hearing
Okay.
versus what doesn't.
So this is, yeah, the state law, this
Yeah.
comes from state law. If you
Yeah.
have a planning commission, you can talk, they have all this language about matters that come, that if you're having a public hearing on something that the planning commission has seen, there's rules about when the board can take it up and when the board has to kick it back for additional review. But when the board kicks it back for additional review, the planning commission actually has sort of a deadline, and there's also, it does actually say, if I remember correctly, in the government code that the public hearing on something that's referred back is optional.
Okay,
The idea
so-
is everybody's gotten notice of it, now we have more things that are being considered. And if the board wants to add public hearing and
Yeah.
make it, they can. But this would be, just like everything
Yeah.
else, the state law minimum.
So we keep the sentence in there, but it's clear that it's gonna have to be agendized and people will become aware of
Anything
it.
we do here.
Because
has
there's-
to
We don't
be
do
agendized.
anything
No,
not in
no, I
public.
understand.
But there's the requirement
that's what I was
for
getting at.
notice of the meeting is different than the requirement for a notice of the public hearing,
Yeah.
right?
Right.
So, I mean, that gives us some more flexibility to get something turned around back to the planning commission in
Yeah.
a much shorter time frame than it would if you had to notice it as a public hearing.
Yeah, okay, I just, I
Right.
didn't realize the
Yeah,
distinction.
yeah.
That's fine, I withdraw my comment. Then I go to the next sentence on required findings, still on page 43.
I'm pretty sure this is state law too, but I could be wrong.
But, okay, let's see. So I suggest that we start that with, instead of just the Board of Supervisors, the Planning Commission, and if the Planning Commission's recommendation has reached the Board of Supervisors, the Board of Supervisors must make the following findings.
I don't know that we have to, because it's like a zoning amendment, this is just, it's not gonna stop with us. We're gonna make a recommendation.
Right.
That they
Right.
make the findings.
Well-
We don't make the findings.
The board makes the findings.
To
based on-
approve, okay, then it's only if it's denied that the Board of Supervisors doesn't have to do it. Okay, so we're not gonna put in there any requirements of findings that we have to make.
We have to, we're not gonna, if you
Yeah.
wanna do your due diligence, you're gonna want to make sure that you agree that the state law findings can be made. You will make a recommendation to the Board of Supervisors describing
To
the
make
factual
the
evidence,
findings.
showing how, just like with everything else,
Right.
showing how those findings can be made. And
So why don't we have it in there that we need to make,
it's not
We're not
necessary.
making the finding
we're not making
anyway.
the findings,
Yeah.
okay,
We're just recommending they make the findings.
Okay.
And this is why.
yeah, okay. Section 07, recordation of the development agreement within 10 days of the Board of Supervisors, apostrophe, and the rest the same.
Not mandatory, but,
Yeah, I don't.
but it's,
I
if you
don't
like,
feel-
if you wanna be formal.
Well, I'm just trying to make it grammatical sense. Okay, annual review, really, annual review.
Yeah.
Do
But
these really happen?
well, we certainly hope so because things have fallen through the cracks.
Now,
It's quite quite a benefit for an applicant to receive one of these. So-
Yes, it is.
So it's a big deal. So
Yeah.
there's, I don't have too much heartburn over.
No, but I think it's hard for the county to, they need a system for knowing what things they need to be reviewing. Especially because they can have bonded for work and work can have not happened and,
Yeah.
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 Okay, then down under B, finding of noncompliance. If the director finds the applicant has not complied with the provisions of the development agreement, the director may issue, why not shall, issue a finding of noncompliance.
Because they can inform the developer without actually doing the formal recording of the letter of noncompliance. They could give the developer a chance to take care of it.
But then it says the finding of noncompliance, which may be recorded at the
Right,
county. So,
they're not required to record it.
no, I understand, and that's clear here, but it doesn't, it seems to me if you find noncompliance,
It's sort of like you find it, you send a notice of
Yes.
violation under code compliance, and the first step, you give them a heads up in writing, you're doing something wrong. And
Yeah.
the general practice is to give them a fair amount of time, a reasonable amount of
chance to
time to
rectify it.
correct it before we cloud their title.
okay,
Right.
so
They-
you do let them know that you have found noncompliance,
Right.
and then try to work it out, and then if it isn't worked out, then you issue the finding.
Yeah, see,
We don't have to
director
say that.
shall specify in writing to the applicant the respects in which the applicant has failed to comply, so that they get a letter
Right,
telling them
right.
what they need to do.
Right.
That, to me, that sounded like something subsequent to a finding of noncompliance.
Well, the finding of noncompliance gets recorded,
I
so,
understand.
yeah.
Um, Should we just change the order here so that if the director finds the applicant has not complied with the provisions of the development agreement, the director shall specify in writing, I'm skipping down to what you just read, to the applicant the respects in which it has failed to comply and should set forth reasonable time, blah, 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 blah.
Sure.
And then, have that as the first step, and then issuing a finding of noncompliance. to
Well,
the
I think what this is trying to do, obviously, there's all sorts of informal things that can happen before this kicks in, but once this kicks in, this is how it happens formally. I don't know that we need to recognize the informal piece
Well,
of it
Well,
before.
isn't the informal, the sentence about shall specify in writing?
Well, I think what they want us to do is that if we actually are going to record a finding of noncompliance, then we absolutely have to do the rest of it, the rest of
In
this.
writing. They
In
could
writing.
call them up previous
Oh,
to that.
okay, so we
saying-
just imply that, or we just infer that we're gonna be good guys and let them.
Well, it's not mandatory. It's
Right.
about, it's our usual discretion to do
Yeah.
things behind the scenes before bringing them in front of you for like revocation. We try to work with them. We
Aggressive
don't need to
discipline.
put.
Yes.
But what we do as a courtesy before playing hardball doesn't necessarily need to show up in the ordinance.
Okay, but if the final conclusion is that they haven't complied,
Then we have to do all of
then
this
you
stuff.
have to issue a finding of noncompliance. That's,
And they can appeal it.
yeah, okay, anyhow, nobody else is troubled by saying may issue instead of shall issue. It seems to me when there is a final conclusion that there has been noncompliance, then the director needs to be required to issue a finding of noncompliance. Anyhow, I'm not gonna beat this dead horse anymore. I do suggest at the end of that paragraph, if appellant does not comply with any terms of compliance within the prescribed time limits, the development agreement shall be subject to revocation instead of termination?
I think it's a contract,
Yeah.
so
Oh.
I think, I mean, I wouldn't
It's
mess
not
with this
something-
language
Okay.
without digging into the
I didn't
state
know.
law.
Okay. And in the next paragraph, interested person, do we have a general definition of interested person that would apply to this? It seemed to me that was under specific provision.
We would have, I mean, that would have all been the same thing with our general appeal requirements. I don't think it would be any different than our general appeal requirements, which we've already gone over.
Okay.
It's an interesting one in this context, though. Any interested person, somebody who's not even a party to the development
Well, yeah, because the development agreement
Yeah.
does have I mean, think about it. You have to think about CEQA with this, you have to think about how it could
Right.
affect, there could be interested people besides the parties to the.
Yeah,
Mhm.
it's just,
Okay, I'm then going to 090 subsection B. Mutual agreement. Instead of any development may be canceled, then we want to say any development agreement with capital D, capital A may be canceled. Or do we want to say terminated there?
yeah,
Since we're saying terminated elsewhere.
I think it should say a development agreement,
I agree.
and it probably should say
I
terminated.
agree with that also.
Again, unless there's something weird in state law where they wrote it badly and then they insist that we write it the same.
And then again, under recordation, if the parties to the agreement or their successors in interest amend or cancel, again, do we want to say terminate?
Yes.
That's what we
but-
said about.
I was dealing with B before, now we're dealing with C, subsection C.
Mm-hmm. Be consistent.
Okay.
I mean, again, I'm assuming that there's no distinction in state law right now between canceling and terminating. There's things like that in the Williamson Act that are not intuitive. So like the big caveat here is let's make sure
Right.
the state law doesn't have something weird.
Yeah.
Yeah.
If we can use the same term throughout, but that'd be best. That's all I have in that chapter.
And here it's unless modified, amended, canceled, or terminated.
So in zoning amendments? Oh.
I had some comment about development agreements, but I can't find it. It might have been in that older version when I was reading through. Which I only had because Julie's comments were on at night, so I might have confused something. See anything here that I marked, so, yeah.
I don't see anything else on my current list.
So on to zoning amendments,
Zoning amendments.
1712.
Okay.
we're almost done.
I feel that the thickness of paper left is pretty small.
Under procedures, I'm looking at 050A. We just assume that people require or are aware of the pre-application review revisions. I was suggesting in my draft here that we put in after pre-application review, if applicable, pursuant to section 17.02.030, a qualified applicant shall submit. That might be considered just, it is required. I mean, it's required for many zoning amendments. But do we need to give them notice here about the pre-application review? Yeah. Our reason for the pre-application review is to have people avoid doing the full application. Unless they're aware of it, they might.
Did we require it for like conditional use permits and other things, or?
Well, we haven't written it in,
Go back and look, Martha, I think it's, commercial and industrial projects?
Right.
And then optional for everything else?
Yep.
It just comes down to the
Pre-application
question.
is required,
Just how
yeah,
much-
for all commercial and industrial projects. Optional pre-application review option for all other types of projects.
Yeah.
So
That's
it's
why I
not
said- That's why I said if applicable. We have it. It just, how much handholding?
Well, why would we want to do, if we do it here, we would want to do it in every.
Yeah.
Everywhere.
And I just, hopefully, at some point, we expect them to read the code, and I'm sure the planning department is gonna have like have a list of things they have to consider in the
Yeah,
order
okay.
that they,
That
on their
would happen.
website.
I would also think when someone calls in, which almost nobody just comes
Well-
in with a
Industrial.
application having never spoken to you
In
before.
actual, all of our instructions for applications also include various things that we need beyond what is stated in code. And so in some cases, we used to, even though it wasn't enumerated in code, we used to require at one time pre-application review of all projects. And so we just stated that right in the instructions. We can do something similar to that now, indicating all commercial and industrial projects must receive, prior pre-application review prior to the submittal of your formal application. And then just state basically what code is saying, all other projects,
Yeah.
it's optional.
And a pre-application review is available on other projects.
Right,
Yeah.
right.
Upon request.
So we can make that
That's great.
statement on the instructions
Yeah.
for
That's
each
perfect.
application.
That's great.
Yeah.
What does 1712.050B say on the current version? Just looking for the screen.
So in 12.050B, staff report, the second sentence, the report shall include but is not limited to a discussion of, I suggest we say whether instead of how, whether the proposed amendment is consistent with the general plan.
Well, but it has to be consistent.
Well, your report's gonna tell us whether it is or not.
Right.
Right.
Well, that's why the whether. If by a requirement that you're gonna tell us how it is consistent, that means that you can't tell us that it isn't consistent.
I just wanted to.
Whether, whether and how?
No,
If,
it's just whether, yeah, if, or whether is as
Well,
provides. the-
Well, then you can just make the statement,
It's-
oh, it's consistent.
right? I think how
Period.
makes sense, because it feels
Right.
like staff would have worked with the applicant if it's not consistent and told them, no point in really
Don't do
taking
this."
this to the planning commission.
Right,
If the applicant insists, disagrees with you, says, no, it's consistent with the general plan, I want my hearing in the planning commission, then you'd want to tell us that it's not consistent. And this
Sure.
does not provide
Right.
you the option.
I understand what you're saying, I'm just,
Yeah.
My concern is more that we don't always have to prepare an environmental document to do a zoning amendment.
yeah, that's what I was just looking at.
Okay,
And I have some proposed language in
Okay.
that,
Okay.
which is, and a summary of how the California Environmental Quality Act, or you could just say CEQA, I'm sure it'll be identified somewhere. So summary of how, and a summary of how CEQA was complied with, and then any environmental document prepared for the project shall be attached to the staff report.
Perfect.
well, again, you're
You have that-
assuming that it is consistent.
Well,
Can't you say whether there too?
I don't think it's necessary, but that's, again, your rodeo.
Well, again, it's just if the applicant says, I want my hearing in the planning commission,
I don't think we would say, too bad we wrote the staff report without the word whether, so you don't get a hearing.
with your language, there's no alternative to finding that it is consistent.
it says how the,
well, then we'll
The
just,
summary of how the California Environmental Act was complied with. The staff's not gonna bring it forward until
right.
it finds
Right.
out.
If
Staff's
it's not-
recommending, it has to explain to you why they're recommending it for approval.
No, But that,
But
but this,
the
if they
staff
could be,
report could be.
he's saying that the report could recommend denial.
Denial.
exactly,
Okay.
and if they recommend denial, and it's not consistent with CEQA, we want to have that alternative there. I don't know, it just seems to me common sense.
It could say a report recommending approval shall include, but is not limited to, and then all, how would be fine, and all of Julie's language would be fine.
Yeah, but a report,
Shall,
but if the
Fair
report
report.
concludes, it doesn't include the recommendation. If you do the weather, well, you have the alternatives in each situation, and then,
I think you can put weather in, and I think in reality, the staff report is gonna say whether it is and explain why.
right,
I think the how will also work, because if you have to include a discussion of how, your discussion is, it doesn't,
Yeah.
How does it? Well, it doesn't. But just to kind of move forward, I think whether can be replaced as well.
okay. So then, when we get around to
there's the
procedure,
10 days.
okay? Maybe this applies to what the education that Julie and the chair just gave me a while back. So that subsection C of section 050, which is on page 48, and subsection A of section 060, I thought maybe were duplicative, but one is talking about a public hearing and one is talking about planning commission hearing. It just seemed to me when I was reading this, there wasn't a need for both of those provisions. Yep, actually, the A, 060A, talks about one public hearing.
Right.
So why do we have to have C, I guess?
You could, so what C is really saying is like, because that's part of this, so yeah, they kind of overlap. So it's really just saying you need to apply, there's a staff report, you have to go first to the planning commission.
Yeah.
And they have to have at least one hearing on it.
Yeah,
And then this kind of explains, well, okay, there's a hearing and then the planning commission makes a recommendation. I guess you could take,
It
I mean,
it doesn't bother me a whole lot, Martha, the way it is. I just raising the question. If you think it just makes logical sense to have both those in there, that's fine with me.
yeah,
Okay. Then in 060B, the last sentence in the first paragraph starts, the recommendation shall be transmitted, but it doesn't say who's going to do that. So I suggest that we say the planning director shall transmit the recommendation to the Board of Supervisors.
I'm assuming some of these staff report requirements also would apply to the other, like CUP and AUP procedures. It probably should just be the same language. We added zoning amendments because it looks like it was overlooked in our existing code. We don't have a process. So that's.
It was just assumed.
Stopped us from doing it.
No, we managed all these years.
And then this, again, this section, the planning commission hearing and recommendation, we have several things coming up in our review, specific plans and et cetera, that have the same sort of requirements. I just think we all ought to be, and the development agreements already had this similar requirement. So that the planning director needs to, not just a copy of the proposed minutes needs to go, but a complete record of the application is the language that's been used in other places. So the planning commissioner shall transmit to the Board of Supervisors a complete record of the application.
It should probably just be consistent with the other
Yeah, which I think
and
this would do it.
in case they're not really interested in reading every bit of what we said.
No, but they certainly need more than the minutes.
Yeah, that's what I'm saying. They might actually like the materials that we reviewed.
Okay, and then under denial, as to be consistent with what we were doing earlier, we take out the word further as far as if the planning commission is recommended against the proposed amendment, Board of Supervisors are not required to take any action unless an appeal is filed in accordance with. Been educated as the difference between public hearing and hearing a matter that's on the agenda. I don't have a problem with anything else in zoning amendment.
General plan amendments?
Yeah.
I go down to 050.
And
Do we have any non-mandatory elements in our current general plan?
I think we do. There was one.
I want to say.
Maybe
yeah.
community,
Economic, oh, there was one way back. I don't remember.
maybe community plans or something like that. Anyhow.
We have the community plans. We have a new community plan element
But is it mandatory?
I
Anyhow,
don't think so.
The question is, if we have any non-mandatory elements, we need to provide for them as far as amendments. Because this only says no mandatory element of the general plan. Either that or we just.
The only thing that has a limit,
Excuse me?
that it's only mandatory elements that have a limit.
Okay. And this is educational to me. I thought we only could amend the general plan 4 times during the calendar year, but
There's caveats. You can do multiple in a single amendment.
Right.
There's other, it's not as simple as you get 4.
Right.
You have 4 times you can come and have a hearing on it.
Yeah,
Well,
They can be.
But you
But
can have
that's
as
not-
many as you want it.
right.
but this sounds as if each mandatory element can be amended 4 times in a year, is what I get from this end. I don't see a general requirement that the general plan can be amended
Only 4 times a year.
only 4 times.
And I want to check it against
Okay,
state law before recommending any language here.
okay.
Yeah, I think I see the way that you're interpreting it, that each mandatory element can be amended 4 times.
Right.
Yes,
My
So you-
understanding is you can
yeah.
only have 4 amendment
4 total
hearings a
amendments,
year.
right.
Yeah.
So we're
But I
saying,
could be wrong about it.
Yeah,
Yeah,
right.
and I could too. I mean, I feel like we need to look at state law.
okay. Julie will check. Okay,
I mean, there's a part of me which wonders, why do we even have to put that in there? That's only for us to worry about. It's not for the applicant to worry about, right?
well, it's,
It's
Yeah.
so good, then they know why it always takes so long to get their general
Right.
plan amendment. on the
Right.
agenda,
yeah,
And why we want to consolidate everybody's together.
Although I don't think we historically have really done much of that because we never get to like more than 4.
well, we
this
could.
year. We'll
um,
be rolling several in together
and
already
again,
this year.
when we get to 070, just make it consistent with what we've been doing in other, 060, 17.12, 060 B is the same. We need to do the same things here to 17.13.070 B.
You want to get rid of that for further.
Further, yes,
Right?
please. Now, it's a question, and this would have applied to the earlier one too. In B1, if the planning commission has recommended approval, the board of supervisors is required to take final action pursuant. So an aggrieved person does not need to appeal. It just automatically goes to the board.
Right.
Okay,
Yeah, it's
General
legislative.
plan
Only
amendments and
regulated
zoning
for
amendments.
both legislative,
Yeah.
contracts.
Yeah.
Right.
Contracts.
yeah, okay.
And same with specific plan.
Yeah, same thing.
Yeah.
Okay, if we're ready for specific plans. The purpose, this is one time where the first paragraph is fine, or the paragraph under purpose is fine, but I think we need to define or describe what the purpose of a specific plan is. The purpose of the chapter is to establish a process for specific plans. And,
Well, I'm assuming the government code that we cite to will actually explain the purpose better than we can.
it doesn't do a very good job, but Curtin's California Land Use and Planning Law on page 35 says the purpose of a specific plan is to systematically implement the general plan in particular designated areas. Which I think is a pretty good language.
Page 35 of which document?
It's not a document,
It's a publication.
he took my advice and bought it. It's a great guy.
Actually, I borrowed it, but
Oh, that's, okay.
yeah.
You
So
guys should
the
have this.
language
Yeah.
would be the purpose of a specific plan. And this would be added after what we have under purpose, is to systematically implement the general plan in particular designated areas. No, I looked at the general code and I thought, well, it's gotta be there.
Good for you.
So we haven't done that in any other section. I'm wondering if instead we want to refer them to a definition of a specific.
Well,
That might be
I think
better.
you'll find, what, under development agreements?
Oh, it's the second sentence in the, or the second paragraph. Development agreements are intended to accomplish two primary purposes.
Right. So, I mean, I think it's good to have something at the beginning that tells you what we're dealing with.
We can add it.
Thank you.
I'm looking at 65450. And it says, after the legislative body has adopted a general plan, the planning agency may, or if so directed by the legislative body, shall prepare specific plans for the systematic implementation of the general plan for all or part of the area covered by the general plan, right under the government.
Yeah,
That's terrible.
but I didn't, I didn't think it was very clear. That's why I thought this other language was,
May, shall.
Well, you can get rid of that
All
section.
of,
Yeah.
how about the language? that I posted?
Yeah, you want to just tell people what a specific plan is.
It is, yeah. It gets them into the mood.
Especially since we don't have specific plans for every place covered by the general plan.
Which is probably a good thing.
And if you're in agreement there,
Yeah.
then section 060, specific plan contents, don't we want to say the specific plan shall include? Because section 65451 requires us to do it. Instead of may include. I mean, here's the language in the government code. A specific plan shall include a text and a diagram or diagrams which specify all of the following in detail. And then most of what we have here is a quotation from 65451. So there are some things where we vary a little bit from the wording of the statute, but the requirements of the statute would be met if we required these things. What the government code does not require is under subsection E, the second part where it says, and a statement of consistency with any existing master plan capital improvement plan. That's something that's added. So everything through F is, except for that one little exception, partial exception, is required by the general code. So we should have it be shall include, but not be limited to, I think. We have that. Then under G, this is something that is not required by the government code, so we could have a separate sentence saying a specific plan may include any other subjects that is blah, blah, blah.
Or you could just make 1714060 A and then go 1, 2, 3, and then B would be the sentence.
Yeah.
Yeah.
That's good, I like that.
What was that, Julie?
So it's basically indent, like have A and B, and everything right now that is A, B, C would be indented and would be 1, 2, 3, 4. And then, because those are all of the shalls, and then the optional additional things would be section B.
Okay.
And that would be limited to, what's now under G, and that would be a specific plan may include. So that's, wait a minute.
Actually,
Well, no,
I actually think
shall
G
include
would-
any other subjects that in the judgment of the planning director are necessary or desirable for implementation.
Okay, I mean, as long as it's, you get the discretion in there, okay?
Yeah, 'cause
Right.
it's kind of built into the sentence.
Okay,
So leave it as it is.
Well, just that G could be part of the shalls. It shall include anything
So
that
then
we
you don't need
determined
another
is
B.
necessary.
It would just be
so
leaving
we
it.
don't need that.
Yeah,
Yeah.
So
okay.
we can keep it the way it is. It's just that the state requires through F, but we will require G.
Right.
So no change?
So
Just,
just
this
when-
may
at
becomes
the
a
very
shall.
beginning, may turns into shall.
Yes,
Okay.
that's it. Good catch. Commissioner Ladish.
Won't like it very much. Then conforming the review procedures to what we've done on pages 43, 48, and 51, 52.
We're attempting to be consistent.
We'll get there.
It's our opportunity.
Yes.
Findings?
Findings. I think we need to have a finding that,
That all of the requirements
Yes.
are there.
exactly,
All the shalls.
that the specific plan includes all the contents required by section 17.14.060.
No, they're different things, though. The findings. Those are the materials we need to make the findings from.
Right.
But those are contents of a specific plan. It says a specific plan shall include text and diagrams, include all this stuff. So these are all things that need to be included in the specific plan.
Right.
So why don't we have
Well, we would.
required finding that that's been satisfied?
Well, our finding is the specific
Plan itself.
implements and is
Right.
consistent with the general plan.
Right.
Well, that's what all these things are saying, like.
Right.
Any other subjects in the, are necessary or desirable. A statement of the relationship of the specific plan to the general plan and how it implements the policy of the general. These are the background materials that allow us to make.
And so in your
These
facts,
findings.
so after you're in your facts supporting the finding, you would go through and describe how it meets the elements.
All these
Right.
Yeah.
Okay.
That works.
That's a very loyal approach. Then under 17.14.100, amendments of approved specific plans on page 56, the last page of this whole section.
Minor amendments.
We do need to have, a specific plan may be amended in the same manner as it was adopted. under minor amendments, the second sentence, I would say this director has discretion to require. I mean, the director may at their discretion, doesn't make sense. The director has, cross out may at their discretion, add the word to require.
Martha, has this section, since it's legislative, has it been checked against state law? Or do all specific plan amendments have to go to the board? Is that possible?
Looks like it has to be adopted by ordinance
It's an ordinance, yeah.
So,
or by resolution of the board.
So the,
so I just want to make sure 17, the minor amendment section is actually legal.
Yeah, we can check it. I think this is really, say your specific plan. So some people do specific plans that are so specific that, they're gonna have a 1,000 square foot retail commercial use here. And say when it gets built, it's like a 1,200 square foot restaurant or, a coffee roaster, which you consider food and beverage manufacturing, right? That's like kind of consistent with, and it doesn't alter really anything, but it's, really a minor.
I mean, as long as it's legal, then we're good, right?
Sounds good to me. Should we be saying that this director has discretion to
Wait,
Treat-
just kidding, sorry.
to find an amendment to be a major amendment or something? I mean, this, really, the second sentence seems to progress past minor amendment.
No, I think they're saying that, we're saying that, I mean, again, assuming it's legal, we're letting the director determine that a minor amendment is so substantively consistent with what we already approved that
Yeah,
it's fine. And then
that's
I think it says after that, if they're not sure, or if it's on the fence, they can defer judgment, to you guys.
Okay, what if he decides that it's, okay, so that a major amendment is covered by the first sentence under section 100, a specific plan may be amended in the same manner as it was adopted.
Right.
Yeah,
Okay, and then minor amendments, well, he might decide that it's a rather major minor amendment.
Or it could be a moderate amendment.
Yes.
Besides, we should look at it.
Okay,
enforcement, anyone?
It could be an extraordinary amendment.
that's right. Dress up all those words. We ought to have a dartboard. Well, this one's significant.
We're on the
Okay,
last 2 pages.
last two.
they're biggies though.
Okay, we're not staying past 4 o'clock, so get going.
I think we should redraft this a little bit to just make it consistent with, as much as possible with how code has 8.06. There's some things in here that, I don't want to suggest, for example, with inspection and right of entry, that as long as we have it stated this way in the ordinance, there's no constitutional considerations before Gabriel can walk in to a closed gate. I mean, there's just,
I just didn't feel comfortable making any comments on it really without knowing exactly what we're really willing and planning to do in the way of enforcement. And is it going to stay the way it is? And, right now, we send everything to code enforcement just about, and
Right.
so I feel like I'm not.
I think the
following
plan,
I think your idea to to undertake a redrafting is a good one.
Okay.
And I think the role of code compliance needs to be
and I just,
clarified.
to the extent we can just refer to 8.06, and I know that we're gonna amend 8.06 at some point, but it would be great to just have it all be consolidated. I don't know how you feel, but the director shall have the primary responsibility. I don't know that Gabriel really wants to be in charge of code enforcement generally. I think we're moving towards code being.
Okay, and also we have the problem under section 030 at the end, this void and no effect problem again. Permit or license becoming void and no effect, so
We don't even need that in there if we've already addressed it elsewhere, I would,
that would be fine. And I certainly am concerned about the entry requirements.
I think that code knows what to do there. They get inspection warrants all the time. I think
Yeah.
that we should just,
If it can be taken care of elsewhere, that's great, because I mean,
And we don't have to update it in multiple locations.
Yes,
yeah, if the,
we can work on that.
okay, we
So,
work on it, that's wonderful.
okay.
What are we gonna do with our Wednesdays?
Well,
Oh,
so
things to look at.
So that's one of the things that Martha and I think, need to, now that we're all together, we'll talk about, just so we can kind of, prepare for the next hearing. So, we thought initially that we were going to bring back edits to you in sections like we've presented them to you. Then we got thinking about it a little bit more and thought, well, that's really going to extend the length of the process. And we think it would be more beneficial for you, now that you've seen it all in sections and we've kind of given our 2 bits and hashed it all out, we think it's more beneficial to bring it all together and present it to you with the red line edits as a complete document. And so she's working on that right now. It's gonna, it's a very lengthy process, so it's not looking as though we're gonna have anything for you, at least not by the first meeting in January, and maybe not even by the second meeting in
Okay.
January. So,
So right now, we should treat our Wednesdays as free.
right, so I don't think, correct me if I'm wrong, Martha, but I don't think we're gonna have anything new for you for a little while.
Just keep us posted, so.
Right. So obviously, we don't want to delay the process, so if, Martha's got a spurt of energy and she's pulling all-nighters and she's like feeling really good about what we're at, maybe she's like, yeah, right.
Well, for my part, now she's just bored. She's got nothing else to do in her life.
Right?
this is like the big, I'm sort of crossing my fingers. This meeting should be the last hurrah until the first board meeting in January. So I hope to take advantage of this time. To
Yeah.
really dig into this and work with Gina
Right.
and Martha on the parts that I'm
Yeah.
involved in.
Yeah, so
Now
Julie's
I
still
can
got some
finally
things.
prioritize this.
Yeah,
Yeah,
I would appreciate it
Yeah.
if, when you come back with that revised draft, if you have some indication of what would be hyperlinked. An asterisk or something of that sort. Or underline or whatever, so that we can say, well, I think you should add this, or, in our usual picky fashion. My usual picky fashion.
Or in blue.
Yeah, whatever, if some indication as to what would be
Yeah.
hyperlinked.
And I just
Not
want-
that it's actually hyperlinked.
No, no.
Just that you intend to attempt to hyperlink
Right,
it.
right.
And I just want to remind the commission that that second meeting in February, I will be out of the office for. And I presume Sarah will be here in my stead, but she's gonna, especially when I'm out of office, she's gonna be slammed. So I was just, to the extent possible, I understand, we're trying to get a lot done. It would be great to keep a fairly light agenda for that one meeting.
So I'm wondering if we have projects or other things coming up on
Yes.
our agenda in January.
yes,
The oak.
Some
There-
real fun ones.
yeah.
So
So
we should plan on both, I think.
you should plan on at least, we're not gonna need any special meetings,
Right.
but
our
you should
regular
at least
meetings
plan
in
on our
January.
regular meetings.
Okay.
Yeah.
Where are we on the oak woodland?
It's sitting on my desk for
I see.
the last bit of review, and that should be it shouldn't take too long now that I have hopefully, I mean, it depends on what comes in as an
Yeah.
emergency every
Sure.
day, which has been a lot. But,
Sure,
I'm the holdup on that right now.
Yeah.
okay.
So if need be, my suggestion is that we add the special meetings back into our February calendar so we can get through the material fairly quickly.
I've forgotten what you asked before as far as our schedule. Were we telling you through February?
I don't,
Would you like us to
Think-
tell you
sure.
whether we're available on
Look
Wednesdays?
in the near, out into February and see what your calendar looks like, and if at all possible, reserve those Wednesdays and set them aside.
But Julie will be gone during part of
Julie will be
February.
gone for, well,
I
2
mean, it's
weeks,
up to
right
you
smack
guys.
dab in the middle.
There's no law saying county council has to be here.
Yeah.
So it depends on what you're comfortable with, but, there's a good chunk of February that I'm gonna be out of the
Right.
office, and it's sort of scheduled in a way to make me only miss one planning commission.
Right.
So I just wonder if we should
So,
plan on not having that special meeting the Wednesday before the one she's missing.
Yeah, I'll be here for the planning commission before and the Wednesday before that.
right, so I
And
think
then-
we
yeah.
could have like a special meeting on the 7th if Martha and I are ready to bring something back to you, right?
The only, unless, again, I have to, I didn't bring my calendar with me,
Yeah.
and I, for whatever reason, I never can log in here, but
Okay.
I, have that, there's always that caveat with the assessment appeals board.
Yeah.
I don't remember when the
And
first.
if we just tell you
meeting is.
which Wednesdays in February and first part of March, whatever,
Yeah,
that we're available, that's what you need from us.
that would be good.
First AAB board, January.
Okay, and that's a Wednesday?
Yeah.
Are they-
There's nothing in February.
Are they holding those in this chamber?
They are, but there's nothing.
That's not in February, so we're okay.
Okay, okay,
Thank you, greatly appreciate it.
okay.
So Julie's gone during our second meeting in February.
Yeah.
And
Yes.
There's a COG meeting, but we don't start until 5:30, so as long as
Yeah.
we're, planning's done by 5.
Well,
We plan
make
to be,
special
So
arrangements.
I'm gonna be,
Make sure that-
gone by five.
I'm out of the office the 9th
Mhm.
through the 26th.
Whoa.
Yeah.
9th through the 20th.
Sorry, 10th through the 26th, with
Yeah.
10th is a Saturday. So it's those middle 2 weeks in February, and then the Monday, the 26th, I'm also off.
Okay.
But if we have, if we've got something that we're able to bring back to you, then perhaps we can get Julie's items out of the way in advance, maybe, and then I don't know if that makes any sense to you, and then circle back around in her absence and go through the things that are less significant
Yeah, I mean, I think we
in
can-
terms of council.
We can pick and choose.
And
Yeah.
like easy, like if you had a couple of like easy project approvals where I could, the agenda materials come out 2 weeks in advance, I can prep her, I can give her a sheet, she can come in. On
Mhm.
easier things.
Right.
As opposed to the big fat contested appeal that we're looking at and,
Mhm.
things like that, so.
Yeah.
Okay.
So, so after we get through, the next round of reviewing the entire document, then the plan is that Martha and I will be preparing the final draft and the zoning changes and bringing those back to you in a public hearing on a regularly scheduled meeting for your consideration and recommendation to the board.
And I think we can do Oak Woodland. As I think about it, I mean, other than the fact that we publish 2 weeks in advance, I think the second meeting in January should be fine.
Okay.
And possibly the first one, if they publish the agenda a little bit, like closer to the 72-hour deadline, but
So we should also probably roll our zoning amendments, like the 7th. The 8th will be the second Thursday in February. So we should go ahead and continue that 7th onto that day unless there's a whole lot of other
Right.
projects
Right.
to get as far as we can.
Right. Because keep in mind, once you guys are finished and you have blessed this document and you're sending it on to the board, we have to send it through legal counsel review before we take the final document to the board.
You mean the mid-year?
Yes.
Yeah, so wait, so we're looking for February on the 14th, what is it, the 14th? And 15th is the first, now what am I looking at?
No.
The
it's gonna be
7th is
7th and
the,
8th. Special
Seventh.
meeting on the 7th.
right,
and then a
7th, special meeting on the 7th,
8th.
regular meeting on the
Okay.
8th.
Yeah.
And then you'll be gone the following 2 weeks.
Right, I have an appointment at 5:30 on Wednesday, but I don't think we're gonna,
No, we won't go that long.
Okay.
I'm off at 4.
all right.
I think seeing it all at once is definitely worthwhile, so
Right.
we can flip back and forth.
Right.
And so don't we need to have CEQA review of this?
So we're gonna have to put things in the staff we're gonna have to recommend before we're ready to take it to the board. There's gonna have to be a discussion of why it's within the scope of the general
General
plan,
plan.
EIR.
Okay,
I would recommend, I don't think it's gonna have to be a major undertaking, because I think we're pretty, I mean, it looks like we already had it reviewed to make sure we were staying within that
oh,
scope.
okay.
But in terms of the language, I would think we would probably want to give outside CEQA counsel a once over on that.
Right.
I don't think it'll be a big chunk of the staff report, but just to make
Right,
sure.
and that's why we're holding out those few items that we think might be,
Yeah.
yeah.
So,
We also have to, well, I guess we can, at some point, it has to go to the airport land use commission.
I am meeting with Elena tomorrow, and we're gonna try to get that scheduled.
Not the whole thing, just the portions that are specific.
Right, and I have to
the
figure,
airport.
yeah.
And they have convened, we've gotten a move on, and I think they have they have found each other after.
Yeah, yeah.
And some people are still like, oh yeah, I'm still on there. I just was waiting for something to happen. And we're gonna have a bona fide quorum, to hold that meeting.
Yeah.
so
And we just want
Speaking of.
everybody remind me, if we don't put it in there, we can do airport land use compatibility plan consistency finding to be recommended in addition to the general plan consistency finding. So I have notes to that effect, and somewhere over the holidays, I'll be organizing everything on it in a to-do list.
So would you like to entertain a motion that we continue this matter until Wednesday, February 7th?
Yes.
I so move.
Second.
Right in there.
All in favor?
Aye.
3, 1, 1.
Aye.
So do we have any sense of when we might get a 5th commissioner?
I have not heard yet, other than I know Supervisor Stopper, I think, he knows about the issue.
Yeah, I hope so.
He might
Yeah.
not be aware of just
How much of an issue?
how hobbled we are
I'll
at the
check in with
moment.
them. I'm happy to check in with them. It's fine.
And then we will definitely want to make sure that Commissioner Parker is planning to join us in February, or actually in January,
Yeah, no, I think, we assume
or at least
that.
have a sense of when he's going to be able to join us so that we make sure that the rest of us are all here.
I just, I don't know if it's fair to him to say, well, what are your plans for January at this point?
We ask everybody what their plans are.
Well, I don't.
Each and every one of you has made a commitment.
Yeah, yeah. and-
That's all I'm gonna
And I'm
say.
sure he's gonna fulfill his commitment as
Yeah.
best he can.
And if you're
And
not,
that seems to go day by day or week by week.
Well, I think the question is there any reason any of us would, that's what we need to know.
Yeah.
Is that we will all have at least 3 people.
don't get sick.
I plan to be here for everything.
Take your vitamin
unless I
C.
Get sick or something.
Yeah, I sent you an email already saying that I'm available every Wednesday, January, February, and
Yeah.
even March. Okay.
Yeah, if at all possible, set it aside.
Yeah.
Good. I plan to be here.
I plan to be here too.
I
If
won't
we
leave.
don't have a meeting, then you've got yourself a free day.
I won't leave, I'll
Exactly.
just set up a tent.
Yeah, go to lunch with your friend.
Okay,
Right.
once again, thank you,
Thank-
Gina, and thank
Thank
you,
you,
Martha.
everybody. So I don't, we don't have a final report from our planning director because he's given us his report. Do the commissioners have any report they'd like to make?
Well, I'd just like to say that I appreciate the staff the support and the consultant report, including the support we're getting from our legal counsel. It's valuable.
Yep.
I
All of
appreciate
that.
that knowledge that everyone seems to.
We're putting it over pretty well. Huh?
And our consultant.
Yeah.
Oh,
So,
my,
yeah.
yes.
Yes, we appreciate everybody. It's been less painful than it could have been. That's for certain.
Well,
It seems, I mean, you put
It's
so
very,
much
it's very helpful and so nice having, such a reliable consultant. Martha's just been great to work with. She's just so knowledgeable and Julie and I've been leaning on her quite a bit, so it's just nice, to have that, such a qualified individual that's been so patient with us.
And she's here.
And she's here.
We won't contrast it with any other. Quite as smooth.
Yeah.
She's spoiled us a bit.
She has. I just have to say that, the county made a good decision in contracting with her and she's been great to work with. And I just have all the confidence in her. So it is great. It's very helpful because there is a lot of, inclusion of new things that aren't really familiar to me. And so it's really nice to have her, providing her valuable input.
I
I
agree.
hope that there's never a need for a comprehensive update of a general plan or zoning code again. We just take the little pieces that are imperfect.
That would be a really fantastic, have a rolling
Yeah.
schedule to constantly.
Well,
be-
that's
Yeah.
the plan. But, it's just like the problem being is that, we've had so much turnover
Yeah.
that, and current planning has really been driving the workload in our department. And so, long-range planning unfortunately just keeps getting shoved off to the side because current planning is that, instant, you've got
You have deadlines.
deadlines that you have to comply with. And so I think you just kind of keep finding yourself in that mode of current planning and you think, oh, these other things are just so much to take care of. It's a huge task.
When is our next housing element?
Well,
I'm sorry.
So
I seems like it's been a while.
I was wondering about that myself.
I'm not sure. I want to say maybe next year.
And all I know is I've heard Gabriel's aware that we're on a different track with it.
Yeah.
He's aware of the applicable deadlines that I know. I don't know. what they
It seems like we
If
might
you
be
want to
getting
know, we can
close.
report back.
Okay, you can report back to
Yeah.
us in February
Or maybe I'll shoot you an email.
or January.
Yes.
That would be great. Okay, we are adjourned. Look, it's not even 4:00
Not
yet.
even.
Thank you, everybody.